Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And now I'm early because I felt bad being late like every day this past week. Normally, like, being late is just charming. But this past week, it was constant, and got finished with actual minutes to spare to come down to the vault and be ready. And so I saw the opportunity, and I took my one shot, like Eminem or whatever. No, like Aaron Burr, right? Or Hamilton. I was not gonna not throwing away my shot or whatever. Yeah, you guys get it. You know what I'm saying. So hey, what's up, guys? How are you today? What a day, man. Quarantine is wearing on me. It is wearing on me. I don't know if it's wearing on y'all, but it is. Oh, it is kicking my butt, man. But here's the problem with being early or on time even. I now have to wait like 5 minutes for everyone to show up. I mean, look, there are good parts. There are good parts to this quarantine. There really are. I don't have to drive 98% of the places I normally would have to drive. I don't have to do that. Really nice. But I would like to go to a restaurant and eat once. And not like shove food in my face in my car or something. You know, like I want to just go sit down and eat. Have a good meal somewhere. Or whatever. But we will persevere and make do. I have to correct a wrong. Always lead with your mistakes, right? And I made a genuine mistake the other night, and I need to correct it. And so I am pulling up that said mistake. Well, I'm pulling up the credit where credit's due. The person who called out my mistake, or the one that I saw anyway, and it hurts. It pains and stings me for this. So, but that's the integrity part, is having to swallow the pride and own up to being wrong about something. So let me get that pulled up, and here we go. Although they're wrong about why I was wrong, but I'll explain. Doesn't make me less wrong. They're just you know, they're just being who they are, which is fine. This is okay. I don't mind. I don't mind taking my licks where I earn them, right? Where I earn them. So in just a minute, we'll cover the wrongness. We'll issue the correction, and then after that, we're gonna get back into Funimation's documents. We were on page 37 of their filing, which means we should go ahead and wrap up their filing tonight. That should not be a big problem. And then we've got the schedule for the rest of the week. Well, I don't have the rest of the week scheduled. I shouldn't put it that way. I have a couple things scheduled. So we'll do that. Monday. Because reading through these documents is really boring. It's a legal brief, right? Legal briefs are mostly boring. These have some special ability to be mildly enraging just because they're full of all sorts of inaccuracies and spin. But other than that, they're still boring. It's just the same thing. We've been covering this for a year. We know the facts. We know all this stuff. It's the same arguments. All of that. So, that being said, tomorrow, Monday, Ronversations episode 10. What? Ronversations episode 10 tomorrow. Monday, we will have a break from the boring old document search. we will have a break from that. We will have Ronversations 10 on Monday. On Tuesday, we will go back to Ron and Monica's brief. All right? Suffer through that thing. On Wednesday, the Human Sunbeam. Ethan Van Sciver will be here to talk about Wrecked Planet. To talk Cyberfrog, Wrecked Planet. That is Cyberfrog 2 or whatever. To talk about that. His crowdfunding for it is going amazing. Let you guys know how you can get copies or whatever if you're interested in that. If you want to see what one of the top guys in indie comics is doing and how they're building that business and building the market, because they're not just building a business within a market, they're setting up the people who are really pushing this independent comics thing, whether it be Comicsgate or Doug TenNapel or Mike Miller. I know there's drama, right? I'm picking these names intentionally. No, it doesn't matter where you are on the drama. Like, that stuff is all, that's you. That's all you. I'm not talking about that right now. What I'm talking about is whoever's out there, they're doing more than just building a business within the existing market. If they were doing that, they'd make another label and try and compete with Image, Marvel, and DC. They're not doing that. They're directly competing for your attention and your patronage through YouTube or other means to create an independent market for themselves and the people around them, right? A good capitalist makes himself rich. A great capitalist makes money for everybody in their circle. And they're doing it. And they're not all doing it together. It's not, but they're sprouts of it. And that's cool. And so I want to talk to Ethan about that. I want to talk to him about the big mistakes and big blows to the comic book industry, Diamond shutting down distribution, how that's affecting all these people. And then, of course, just some cheer and good times with Ethan. So that's Wednesday. Thursday and Thursday is still an open day at the moment. I'm working on shows for Thursday. Friday, Big Brain Panel. Big Brain Panel is on. I believe we have the 3 full-on members of the Big Brain Panel committed for that. I need to get final verification on it. And Ty Beard will be joining on the Big Brain Panel as well. So I have laid out 4 of 5 shows for this coming week. So hopefully that schedule excites or entices you a little bit and lets you know that there's work being done. There's a schedule on the books. You know what to expect. And I think each of the days should be a good show, right? Thursday is still up in the air. I'm not, it might be a buffer day if there's a need for another episode of Ronversations. I don't know. I never know how long it's going to take, and he has sent me some books. So I never know just exactly how much time I need. So Thursday might be overflow for that or overflow for Ron and Monica's document. We'll see. We'll see how it goes. I'm trying to keep the YouTube show as close to 3 hours as possible when I don't have a guest, especially. 1, for my own sanity, and 2, because it's just tough doing longer than 3-hour shows. But the Twitch streams are there in case if you need content I'm not trying to limit content, but you know, Twitch is there as well for longer than 3 hour type stuff. If I have a guest and we're jiving, of course we're gonna go past 3 hours. That's just how that goes. But just want to let you know what I'm going through right now as far as like show planning and stuff like that. Now, one more thing to bring up. I put up the second video on my alternate channel. This video is brought to you by my other channel. I did the second video on my other channel covering Lionel Johnson, the Primarch of the Dark Angels Space Marines. This is the special edition Primarch box set. Or box. It's not a set, but yeah. I don't know. If you guys want to go check it out, it's there. Need a link, you can check my community page. It's got the link. I think there's a link to Rekieta Media somewhere on your side of things. I can't see it as easily, but if you guys are interested in just nerd stuff, that's what it is. So far, there's 2 videos. They're both book reviews. Just as an idea of what other things might go on the show that are not Warhammer specific. Like I have this Robotech YF1R, right? So we might go through what this thing is, or, you know, nerd stuff. That's it. If you like that type of stuff, come check it out. Come check it out. So, that being said, let's get into this. Let's get into this. Pants, these are shorts. Thank you. Thank you. These are shorts. Don't oversell me here, and don't you dare disparage me by suggesting I'm wearing pants. Springtime is here. I will not wear pants again until winter. Hentai review on the new channel. I'm not opposed to it, except that I probably am opposed to it. But anime reviews and other stuff, yeah. Anime reviews, video game stuff. I'll probably, if I get like particularly interesting things happening on a video game or a good clip that I can share from Twitch, I have to wait 2 days and then I can post it to YouTube. That type of stuff might show up too. You know, I don't know. It's kind of just a fun, more relaxed channel. Let's get to that correction, okay? We've got a good amount of people here. They have compensated for my normal latent gayness. And we've got it. This pains me. Look at this. Mike Dunford. And he gives me the benefit of the doubt. Oh, Mike! Mike, don't do it. Don't do it. I'm still going to make fun of you other times, but this time I won't because he's right. Sort of. I said the appellee's briefs were over their word count, and that is because I misread the rule. More accurately, or specifically, I glossed the rule. So the rule says briefs and responses, and I read briefs, and then the next subheader is for replies. All right? So that's what happened. Completely my mistake. 100% own that mistake. I don't know why, just brain skipped the word. So I got really excited and laughed that their briefs were going to be too long. They are not. They are all within their word count. They do get the full 15,000 words on their response briefs. The reply brief will be what Vic's team gets to do. They get to do a reply to the response, and those are limited to 7,500 words. I do humbly apologize and ask forgiveness for making a mistake. Just read over the rule and glossed it every time I looked at it. So not much you can do about it. But so they kind of have some discussion. Illiteracy wasn't really illiteracy. It's just skimming through the words too fast. I didn't ignore the use of specific words with specific meanings from Cat Lady here. But her name is Cat Whisperer. It's not my fault. But notice what I do. I want to point this out. Hey guys, thanks for letting me know about this. You're right. I glossed the rule and didn't catch the response and reply distinction. It's the curse of live reactions and musing on the fly. I'll clarify it on my show tomorrow night. I posted this yesterday. So just a little bit after saying I wouldn't do the show that night. So that's where it was. Oh God, I'm sorry to do that to you. I didn't mean to put Mike's profile picture up there. But yeah, what do you do, right? Like, I wasn't gonna argue with them. They're correct. I was incorrect. And we won't go into what happened after this because I don't want to dwell on it. But a brief summary, you can check out the thread for yourself, of course. A brief summary of what happens is this lady, Cat Whisperer, thinks that I'm like arguing with her here or something. I don't know what the deal was, but I was talking about something else entirely. It was a weird exchange. And then I got accused of making up names or something or making fun of her. Let me clarify that. Let me get up close for this. I absolutely made fun of you. And I absolutely will again at some point, I'm sure. But I'm pretty sure I didn't make fun of you for a cat thing. I'm pretty sure I didn't make up a mental illness for you. I'm not saying that didn't happen from somewhere, but I don't want to take credit for someone else's work. I don't even know what the mental illness joke was. I would like to know, because if it was funny, I'll consider Carlos Mencia-ing that joke. I'll consider it. But I don't know. I don't know at all if you're crazy. But you might be. I don't know. Anyway. So Mike traded in his tuba for a trumpet for one day. And he gets all the win. Like I said, I wasn't going to argue with them or anything. They were 100% right on this, and I got it wrong. And I own my errors and mistakes. So, cheers to Mike Dunford and Cat Whisperer Carhifer. Whatever your real name is. I don't remember or care. Barely care that you exist. Won't care when you don't. It's not personal. Okay. That being said, that little mess is out of the way. So thank you for bearing with me on that. Oh, hi, Ty. Okay, so someone sent 2 super chats yesterday while there wasn't a stream, or not super chats, I should say justice chats. And I want to read those. And those are from Will. So Will says, thanks for all the entertainment. I can rarely watch live. I always watch the replays. Aw. I hope you're practicing drinking with the Greer lips for the Greer stream. Oh, when is the US taking over my country of Canada? I miss free speech and lost liberties. Dude, we're with you. We stand in solidarity with the tyranny of all the other countries right now. We're with it. In Minnesota, listen to this, guys. In Minnesota, okay, cops driving around, because very, very essential for cops to still patrol when no one's really out. Sees something, and he gets a cop hunch, right? Deep down in his cop balls, he knows. He's like, oh, yeah, that's some criminal mother effers over there. Phew, I got him. What does he see, right? Now, this takes years and years of extensive training. Cop hunch instincts. You hear about it on TV. You hear about it in filings, news stories everywhere. That cop hunch, that specialized training, deep core primal instinct of something being just wrong and boots needing to be licked, right? He looks at a bar. It's called Shooter's Bar, because there's a Shooter's Bar everywhere. I don't remember what town this is. He sees 4 cars in that bar parking lot. He's like, oh man, something's wrong. Something is wrong. He goes. He opens the door. What does he find? Illegal activity. Of course, it's a cop hunch. What wouldn't be illegal about it? Of course he's right. He sees 4. Is the bar open for business in the quarantine? No. No. Not at all. He sees the bar owner and 3 other people hanging out in the bar, chatting and playing cards. Oh, baby, is he excited. Issue in those tickets. Tickets all over the place. Put those disease-spreading, rule-breaking, freedom fighter bastards down. Oh, my goodness. Whew. Keeping the world safe. Those guys could have infected hundreds of thousands of school children from that bar by themselves that was closed for business. That's just one of... This is a couple days ago. Dozens of tickets, citations, criminal citations have been issued in Minnesota for this stuff. Not for, like, running a massage parlor against government orders. Not for, like, running in and coughing in the face of all the children at an elementary school. No. Some people meeting privately in a closed establishment that one of them owns. Did any of them have corona? Who cares? Who cares? Who cares? It's literally the same. By the way, it's the same as going to your friend's house. If you've done that during quarantine, not that I would. Woo. I would never do that. But it's the same thing. Like, that guy owns the property rights, or at least is leasing them for the bar. I don't know if he owns it outright or if he's leasing. It doesn't really matter. He's responsible for it. It's his property right. He has the right of possession. Someone goes to it. It's just like a house. Not running a restaurant. Not letting people in. Anyway, it's just this is stuff. So that's to Will. We don't have free speech or lost liberties now. We don't have the right of association, peaceful assembly. It's gone. It's just gone. There's a virus, bro. It's gone. One last thing I want to say about the virus and all of this and the civil liberty. I know I'm the libertarian dummy yelling from the rooftops pointlessly. I get it. I get it. Civil liberties only matter when it's hard to uphold them. Don't matter. Please and thank you is not free speech. Because everybody wants to hear please and thank you. It's fine. That's perfectly polite conversation. Dropping the N-word or, criticizing your government or making fun of someone's religion or all of those things are the uncomfortable aspects of speech. The parts where we're like, whoa, jokes about dead babies are really uncomfortable, or jokes about babies raping immigrants are really uncomfortable. Like, oh God, hentai is really uncomfortable sometimes. The movie Before Night Falls, about a man whose last name Uranus rhymes with anus and is about him getting his anus reamed out. for like 50 years of being a Cuban exile. Really uncomfortable stuff that no one wants to see or hear about. That's when speech matters. That's when your rights matter. Your right to not have a soldier in your house doesn't matter when you don't have a soldier in your house, right? It only matters when the government puts a soldier in your house and says, up, feed him and give him a bed. Wait, what? No, I have the right against that. Well, there's a virus, buddy. You got to keep a soldier in your house to make sure you don't leave. Think about it. Would you tolerate that one? Just put a National Guard member in your house. Just to make sure you don't leave. Just going to be there. It's your Third Amendment right, by the way. It's just as important as your First, Second, Fourth, Fifth, Sixth. It's all the same. All the rights matter just as much. And your Fourth is next on the chopping block, by the way. That Fourth Amendment right against search and seizure, which has an implied right of privacy when you combine it with the Ninth, that's coming. And they just go ahead and require you to register your corona thing. Or if you're in Kentucky wearing ankle monitors, right? Just locked in your house wearing an ankle monitor because you're a viral risk. Think about it. Think about it. Anyway. Okay. So that's enough of the freedom talk for tonight. Got to do it every now and then. Will also said, he actually said this first, I think. Hey, Nick, with all the book suggestions Ron has said to read, you should mention to him to read the inspirational novel of Why I Sued Taylor Swift. Or when Ron is upset, suggest to watch the inspirational dance of Russell Greer. We need more Greer streams. Yeah, I'm working on the one. Like I said, I gotta talk to Sriracha about filling out that show because the document isn't very long. It's funny, it's great, and it puts straight to bed this one of these ideas of his that he didn't do what he absolutely did. That's fantastic, but it's like maybe a half hour of content, even with jokes. All right, Gay and Still at Large says, hey there, Delilah. What's it like in New York City? I'm 1,000 miles away, but girl, I want to see those titties. I have too much money and I'm too drunk because Corona Chan closed basically everything but the liquor stores. Thank you, Gay and Still at Large. I like the first line of your song. I think you should round it out. It'll be great. Eric Stein says, hey, Nick, almost died. Got stuck in a snowstorm in the mountains. Made it down in a Damagud truckload of food safe, but been up for 20 hours. Dang, buddy. I am glad you lived. Goodness gracious. Where are the snowstorms in the mountains? Up in Colorado or something? Mark C says, Nick, I sent you a DM concerning a report my company filed on me because my girlfriend contacted COVID-19. Please, I need to know if this is even legal. I will look for your DM, but let me just flat out say it. You don't have any civil liberties right now because you don't have a court that will enforce them. You may not even be able to get your case in front of court. So I'll see what I can tell you. Is it legal? Right now, everything's legal. It all legal, buddy. Hey, Stings says, Nikki, weren't we going through Ron and Monica's documents? We were, but I broke the Funimation one to do Ron and Monica's, so we'll go back to Ron and Monica's on Tuesday. Also, my book is free through lockdown. Just DM me at Mr. Will Hastings on Twitter or Instagram. Not you, though, Nikki. I know books make you fall asleep. They do. It's really hard because I love to read, but I love to fall asleep reading, too. Ray Drake says, Corona Chan ruining things for me. Work deemed essential. By no one is getting their cars fixed. Vacation canceled, and I had planned to propose to my girlfriend Deering. Mind having a drink with me? I'm drinking Woodford Double Oaked. Well, buddy, Bareface, Canadian whiskey. Sorry to hear about the delay in your proposal, but just remember, You could delay your proposal for years and still get married before Monica and Ron. Cheers to you, pal. May you return to your girlfriend soon. There we go. There we go. All right. Now, we are up for some documents. So here we go. This is great. Above all, fatal to Vic's defamation claims is Vic's failure to show causation. Funimation also pleaded that Vic is libel proof due to the long-standing public allegations of sexual misconduct made against him, which defeats the causation and damages elements of Vic's defamation claim. Sorry, you have to plead every element of an affirmative defense by preponderance of the evidence. The trial court decided not to hear your affirmative defense at all, actually. So you definitely didn't make a preponderance of the evidence finding there. And neither did Judge Chup. The other problem is, if he was libel proof, why were you hiring him? Why'd you hire him? His reputation, their argument is his reputation was so bad that the statements against him couldn't have caused damage. Yet, the statements against him caused them to fire him. What? What? Huh? 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 He lost. We had to look into the statements about Vic because we saw him on social media. And so then we fired him after the investigation. Now he's libel proof because of the statements. Huh? What? Huh? Now, obviously, Funimation's statement couldn't have damaged Vic, causing Funimation to fire them. That's certainly true, right? Like, Funimation fired Vic before Funimation goes on to defame Vic. He didn't just become libel proof. Like, you don't just become libel proof. Maybe if you're, not even if you're convicted of murdering someone, do you become libel proof? Because, like, if you murdered someone, that's just true. So, libel proof is such a, like, it's a high bar. A very high bar. Anyway, and their claim just doesn't make sense. A libel proof plaintiff is one whose reputation on the matter at issue is so diminished that at the time of an otherwise libelous publication, it could not be damaged further. Well, that's just not true. It's just not true. Because Funimation had fired him, people were supporting him, and then after Funimation's statement, Monica and others piled on talking about, yeah, see, sexual harassment or whatever, right? Like they just added to it. To apply the libel-proof doctrine, the evidence of record must show not only that Vic engaged in criminal or antisocial behavior in the past, but also that his activities were widely reported to the public. And this was proven as a matter of law through Rial and Toye's evidence. Nope. It certainly wasn't proven as a matter of law through their evidence. And Chup doesn't make a finding of that at the trial court at all. So, very, very interesting. Vic also denies all of it. And has. He's denied all of it consistently. Part of their evidence is that he's denied the rumors publicly. Part of their evidence is that he made a public apology which denied the allegations. The only evidence that they don't like, they really don't like, is that declaration of Vic's that says that he denies everything in every one of the affidavits that were brought against him. So, libel proof, it's a long shot, of course. All the conventions that Vic identified in his first amended petition canceled Vic before Funimation published its tweets about the Vic Mignogna situation. That is not the sole source of damages. Shockingly. You could just damage someone's reputation whether a convention cancels them or not. Like if I make it widely known that Ron Toye is a rapist or something, hypothetically, right? I have no evidence of that. But were I to fabricate a claim that Ron Toye was a rapist and a bunch of people ran with that, if they all did that and he didn't get fired necessarily, or he didn't not book a convention that we can identify, we can still know that these claims are defamatory per se. They're so defamatory that there isn't a presumption of damages because we know that the accusation is so damaging to someone's reputation that it will cause them harm. But either way, Vic can show lots of damage. All you have to do is screenshot tweets about him that are subsequent to Funimation's thing. In fact, there are 60 to 90 speds on Law Twitter right now who freely claim that Vic is some sort of pedophilic rapist right now. And that's following the Funimation tweets. That was prior to the trial court's decision. And it's all because of Funimation's giving credibility to the claims of other defamers. I mean, you can show his reputation has taken a hit. Hell, his colleagues say it's taken a hit. Funimation employees are out there right now trumpeting how it's taken a hit. Ron Toye has told me 1,000,000 times that Vic's reputation is worse now than it ever was. I don't necessarily believe him, but he clearly thinks so. Funimation has defamed Vic in Ron Toye's eyes. And Ron Toye has referenced Funimation's investigation for many of his beliefs about Vic. So you tell me how his reputation isn't diminished. That's damages. Well, what's the monetary value of those damages? That's a fact question for a jury. Again. Jospy says, speaking of marriages, a coworker used our work phone to order an escort for a blow and go. I looked up the number and she's not hot. Also, 140 for half an hour? Oof. Really don't know if I should let his wife know or leave it. Look, buddy, that's not on you. Not on you. You don't know what's going on in that situation. It's not on you. Not your job to intervene in that. If you have a close personal relationship with him, you bring it to him. That's how you do this. You bring it to him. You say, hey, man, what's going on? This is going to wreck your marriage. It's going to wreck your life. You don't want to do this, all that stuff. Maybe he says, you know what? It's already over. What are you doing? Then why are you calling the wife? What good is that going to do? Don't be the guy. Don't be the guy who gets in between a man and his wife. Don't do it. It doesn't work out well. 9 times out of 10. Just doesn't. If you're friends with the guy, close personal friends with the guy, you talk to the guy. If you're close personal friends with the wife, it's a different story. That's a whole different thing. Why are you close personal friends with the guy's wife? Anyway, it's not your job. Don't deal with that. Trust me. That stuff always turns out bad. That's you getting shot for him getting a blowjob, right? Don't do that. Thus, Funimation's tweets could not have caused conventions to cancel Vic. Accordingly, Vic's failure to provide clear and specific evidence that Funimation's tweets caused him any actual damages required dismissal of Vic's defamation claim against Funimation. Trial court properly dismissed Vic's tortious interference claims against Funimation. There's also no reason for the court to reverse the trial court's dismissal of Vic's claims against Funimation for TI with existing and prospective contracts. Footnote. To withstand dismissal for his claim of TI with existing contracts, Vic was required to provide clear and specific evidence that he had a valid contract with a convention. Funimation willfully and intentionally interfered with that contract. Funimation's interference proximately caused Vic's injury, and Vic incurred actual damage or loss. With respect to his prospective contracts claim, same thing, but add an underlying tort. So there you go. Actually, interestingly, I think there's more evidence of the prospective contracts. I think there's more evidence of this prospective contracts claim against Funimation than the existing contracts, because while you know, and I know, and everybody at Funimation knows, and all of the other voice actors know, and the engineers know, and every con staff knows, Funimation absolutely has influence over contracts with conventions. Absolutely. If you're on Funimation's bad list, you don't go to the show. Someone's going to a show that Funimation doesn't want there, they can threaten to pull all of their business, and they just won't go. So they have a Mafia Don sort of relationship that already exists. They don't even have to say it. Look, man, if I book you, Funimation's going to pull this person, this person, this person, and I need them at my show, blah, 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 blah. That exists. It just does. Getting someone to talk about it, hard. Getting Funimation to directly say it, much harder. You can, if you're arguing vicarious liability, and the fact that Kamea-con itself had several Funimation voice actors all miraculously decide through no influence of any of Funimation's or Monica Rial's at all, just nobody participating in that, just miraculously pulled all of the existing Funimation voice talent from Kamea-con last year, except for Chris Sabat. I mean, other than that, though, but you can't write that down on paper. There's no paper trail for that except one that leads to Monica, and then you got to argue vicarious liability on it. And that's a tougher claim than her tweeting about Vic, because she does tweet about things as part of her business. She doesn't necessarily shriek on a phone to Chris Slatosh about things as part of her business with Funimation. So it's unfortunately that one's hard to prove. But prospective contracts, Funimation knows Vic goes to shows. He's been going to them for years, with Funimation's blessing, with Funimation actors, as a Funimation actor. And they know what their statement would do to those prospective contracts. If it's defamatory, you've got the elements. So I think the prospective claim is slightly better against Funimation. That said, they're both hard to show. They really rely on that vicarious liability. Much less any competent evidence that Funimation caused actual damages to Vic. Fatal to Vic's appeal is that he failed to link any specific Funimation statement to any specific lost business. Quote, even if it had been shown that a potential customer decided not to book the venue after reading one of the statements at issue in this case, plaintiff still would have to show which statement the prospective customer read. And that's Landry's Inc. versus Animal Legal Defense Fund. I think you could make arguments on that, but it's prospective business relations is a really tough tort in general. Instead, Vic references tweets published by Ron Toye and conventions that allegedly canceled Vic before the date of Funimation's tweets. Specifically, Vic's first amended petition does not identify a single convention that terminated its existing or prospective contract with Vic after Funimation's tweets. Instead, the conventions identified in Vic's pleading allegedly terminated Vic before Funimation tweeted on February 11th, 2019, which conclusively negates any causation as to Funimation. Now, they're talking about specifically the TI stuff. They use the same argument for defamation, but we've already covered that. The defamation can go beyond merely losing a contract. Loss of reputation is damages. Further, Vic has not provided copies of any contracts that he alleges were tortiously interfered with by Funimation. He doesn't have to. He actually doesn't have to at this point, much less any proof that a convention breached its contract with Vic. This is untrue. They have clear and specific evidence of every breached contract with Vic from the convention circuit. They're just all dancing around the fact that it says that announcing someone is part of the contract, and by announcing someone, they had an existing contractual obligation for Vic to appear, for them to advertise. There's an exchange of rights that occurred. Performance had occurred on both sides at that point, and then the contract was canceled. It's spelled out much better, I believe, in the second amended petition. But I do think it's in one of those first two petitions as well. Either way, they're playing stupid here, but they know this is how it works. And all of those are clear and specific. They're also clear and specific prospective business relations if they're not existing contracts, but they are. Someone announces you to their show, you're going to their show typically outside of a breach or outside of one of the two parties saying, actually, no, like if Vic were to say, I never agreed to go to that show, then they have a dispute. That's a separate thing. But if Vic and the convention owner said, yeah, let's do it, convention owner announces Vic, then unannounces Vic, you now are at breach and loss of reputation. By the way, being canceled from a show has impact on your reputation by itself. Or refuse to enter into contract with Vic as a result of any alleged Funimation interference, thereby causing Vic any measurable amount of damages. Granting TCPA motion where plaintiff failed to provide clear and specific proof for his TI claim. Finally, rather than meeting his evidentiary burden as to Funimation, Vic groups all appellees together by asserting he fully expected to participate in the same conventions in 2019, and because of the appellees' tweets defaming him, these unnamed conventions did not invite him to participate in 2019. Yeah, absolutely. Absolutely, by the way. That is 100% reasonable. That occurred. Conventions definitely didn't invite Vic because of the events last year. They're all... People like Ron are relishing this right now. They didn't invite him. He's not getting as many conventions. It's all over. All over the place. They all believe this. Except in the legal filings. Of course. Of course. These unnamed... See Vic's brief in 2021. Because this sort of speculation is insufficient under this court's opinion in Vanderlinden versus Kahn, there's no reason for the court to reverse Judge Chupp. Well, there's lots of them. Vic's failure to submit competent evidence for his TI claim was discussed at length during the TCPA hearing. When asked whether he had obtained affidavits from any conventions about why they canceled Vic, Vic's counsel admitted that he had not. Fucking false. False. Kamea-con. They did obtain an affidavit from Chris Slatosh. They set it on the record. The affidavit was withdrawn, but that's there. The Kamea-con one is discussed heavily throughout that hearing. That's false. And that unsworn declaration was offered to replace the affidavit, and Chupp said, I'm going to consider the affidavits. So they didn't even give him an option to preserve a ruling or objection because he said he was going to consider them. I'm probably going to consider them. I've already read them. I can't ignore them. Order comes out. Ignored. Wait, what the? This is utterly incorrect. Of course, Kamea-con is in there. And Vanderlinden versus Kahn. Wait, no. This line here goes against Knox v. Taylor because the trial court gives very little deference to a breaching party's reason for breaching because they breached the contract. Knox v. Taylor, Texas Supreme Court opinion, and that is, they flat out say, you can't put the burden on the plaintiff to get an affidavit from a contract holder, whom, by the way, it would be extremely hard to get the affidavit. It would be even harder to depose them, to have pre-trial discovery or some sort of bogus thing to try and depose a convention owner to get this. Both practically and legally, it's near impossible. Because in Texas, especially at the time that this was filed, I don't know if it's still true under the new TCPA, but if you filed to depose a convention owner and they wanted to, they could TCPA your deposition. Pre-trial discovery, I'm not involved in this. TCPA, my free speech, leave me alone. I talk to who I want and when. Prove the criminal elements of what you need for the deposition. It'd be the same place. Especially if the deponent doesn't want to go ahead and admit that someone interfered and caused the cancellation. Or if they don't want to admit that they're in breach of contract. Yeah, let me just write it down in a sworn affidavit. I breached a contract with someone. The fact that there is one from Chris Latosh is actually remarkable. It's hard to put that down. It is actually remarkable that someone came out and said, and the only reason that it exists is because they went through negotiations, renegotiated the contract, and are now able to, after having rebuilt that relationship, say, okay, here's this thing. Now I know you're not going to sue me because I did right by me. I fixed our thing. Now I know you're not going to sue me. That's the only reason that exists. Other than that, they'd ghost you. Why would they ever respond? Hey, can you give me an affidavit that you canceled the convention because of this? Hell no. There you go. Ugh. Trial court properly dismissed Vic's claim for vicarious liability against Funimation for the conduct of the independent contractor voice actors. To establish any basis for holding Funimation vicariously liable for the social media of other activity of voice actors against Monica Rial and Jamie Marchi as Funimation employees, Vic was required to show that at the time of their alleged conduct, they were employees of Funimation and were acting in the course and scope of their Funimation relationship. Because Vic failed to make either showing, Judge Shupp properly dismissed Vic's vicarious liability theory against Funimation based on an alleged employer-employee relationship. On appeal, Vic abandons his argument that Funimation is somehow vicariously liable for the conduct of Monica Rial's fiancé, Ron Toye. I don't know that they abandoned it. If they did, okay. But Judge Shupp made the correct ruling because the evidentiary record showed that Monica Rial and Marchi and Rial were independent contractors at Funimation, not its employees or agents. This is not actually true. The evidentiary record doesn't show this. This is a legal question, not a fact question. Or, well, it's a fact-intensive legal question. And the people giving the legal opinion on this were not qualified to make that determination at all. This is actually a question for a trial court. Shocker. And the allegation should be sufficient. Rial's deposition. I'm an independent contractor. That's not the only test there, lady. Copies of Funimation's work for hire contracts with Rial and Marchi. Again, not the only tests. The tests involve what their job duties are, how much control there are. It's like a 20-part test, something like that exists for the IRS. There's like a 4 or 6-part test the Texas uses, the Texas Labor Board. I don't remember what they're called. It's been a while since I've looked at this stuff, but the distinction is significant because as a general rule, an employer is insulated from liability for the tortious acts of its independent contractors. Because Vic's claims against Marchi and Rial sounded in tort, Funimation cannot be held liable. As Vic notes in his brief, Judge Shupp commented on the record at the Tcpa hearing that he would not consider evidence submitted by the defendants' appellees after their Tcpa motion deadlines, which would include the independent contractor agreements with Rial and Marchi that Funimation submitted in response to Vic's best evidence objections. Contrary to Judge Shupp's comment, nothing in the Tcpa precluded Funimation from filing supplemental affidavits to address Vic's evidentiary objections. Wait! In any event, Judge Shupp's written order does not address Vic's objections to Funimation's supplemental affidavits, and Vic did not make any effort to obtain a ruling on those objections. Accordingly, Vic's objections to Funimation's supplemental affidavits are waived. Failure to obtain a ruling from the trial court on an objection to the form of an affidavit waives the objection. This isn't actually true. Judge Shupp's, as we saw, Judge Shupp's written order actually does go ahead and dismiss expressly deny any other relief granted. Not specifically granted in the order. So we do have a ruling. I suppose it's a ruling on the objection. The objection is relief. But wait a minute. This is kind of funny. Anybody see the problem with this? Does anybody see the problem with this? Right here. I'll wait. I know you guys are 20 seconds behind, but if anybody can point out the problem with this line right here, you get a gold star. Here's the problem. Unsworn declarations legally function the exact same as an affidavit. Their function is exactly the same as an affidavit. They are legally operative in the same way. All they do is they include a jurat. A jurat is a statement that is a legally binding statement, and what it says is, I declare under penalty of perjury that everything I say in this document is correct, right? The same thing that you would get for having a notarized affidavit. A notary would administer the oath and affirmation instead of having a notary do it, because that is ridiculous. Just the unsworn declarations allow them, without swearing to it, to affirm in the jurat that it is a true and correct statement under penalty of perjury, the same as administering the oath. We've got now, Judge Chup has denied the objection to the second amended petition and has denied the objection to the unsworn declarations and the supplemental evidence because he just never issued the ruling until his final order, which denies all relief not specifically granted. So he never ruled on them, okay? He just said he didn't consider them. Doesn't rule on them. Then denies it. So he either denies it or he doesn't deny it, in which he doesn't rule on it ever. So if the case is that the denial doesn't exist, even though it's the plain language of that final document, the final order, if you argue that, well, that's not him ruling on the objections though, bro, then he didn't rule on the objection, and they failed to obtain a ruling from the trial court on an objection to the form of an unsworn declaration rather than an affidavit, waiving the objection. So they're in. Funimation has made the legal argument, along with Monica and Ron, that those unsworn declarations, if nothing else, that those unsworn declarations should absolutely be included. Period. And chopped up by not including them, not striking them, or by not ruling on the strike at all. So, there you go. Thank you, Funimation, for the legal argument. It's both and. All they have to do is cite to the rule that says an affidavit can be substituted by an unsworn declaration without issue. It's a rule of the Texas Rules of Civil Procedure. It's right there. And, you know, that's just how it goes. I don't know what else to say. They've made the argument. Hopefully Vic's team will go ahead and respond on that and catch that. I would ram it down their damn throats. Ram it down their throats. And then we have footnote 14. See Dallas Morning News versus Tatum. Various business torts, including tortious interference with existing contract, tort of action such as tortious interference, observing that no independent liability for a civil conspiracy exists as a jury's finding. Yeah, you got to have the underlying tort. Yeah, we know. But Yeah, if you combine the arguments of Ron Toye and Monica Rial and Funimation, that's what you get. You get an argument that those unsworn declarations must be included. And if those declarations are in, especially Vic's and Slaytosh's, it's hard to argue that some of these things don't come back. Here's the real thing. They should be scared of Slaytosh's affidavit. They should be really scared of Vic's affidavit, because Vic's affidavit creates a fact question on every single piece of evidence that they submitted. And he denied them out of hand. And those fact questions at TCPA weigh in favor of Vic. Period. Now, caveat to all this, and shout out to the farms for being constantly disappointed. This is to the farms. I pay this tribute to you. You can make legal arguments all day. You can make very, very good legal arguments all day. Whether or not a judge or even a panel of judges will accept that argument is always up to the human question. Legally speaking, there's no difference between an unsworn declaration and affidavit. Legally speaking, Judge Chup refused to rule on it at the hearing, refused to rule on it in his order. Merely saying he didn't consider them is not an unambiguous granting of the objection, or sustaining or denying the objection. So, and then legally, he either dismissed all other relief that was not specifically granted in the final ruling, or he just didn't rule on it. So legally speaking, argument is those unsworn declarations, at a bare minimum, should be in. In fact, we can further add that they objected to Ty's request for a trial amendment, and Judge Chup didn't rule on that either. At the hearing, Ty said, "Your Honor, I'd like to make a trial amendment to add just the unsworn declarations." Okay? And Judge Chup said, I think I have to consider. He just didn't rule on it. He just weaseled his way out of it. He doesn't rule. They did object to that, I believe. And in that objection, they failed to obtain a ruling. So they've waived it. As an operative legal argument, those unsworn declarations are in by law. They can make the argument to the appeals court all day. We'll have to see how they make it. If they make it competently, we'll have to see. Can't guarantee an outcome ever with a judge or a panel of judges. They can write their way out of just about anything. That's why they're judges and appellate judges. So I know some people on the Kiwi farms are frustrated that you can bring this stuff and then nothing happens. Well, sometimes in the law, nothing happens. And it sucks. Believe me. Believe you me. It sometimes sucks that nothing happens even when you've got a slam dunk. But all you can do is bring it and hope the trial court comes along or the appellate court comes along for the ride. So that's just my special address to the farms and some of their recent discussions, which, by the way, you know, guys, I love you. And you're not wrong. It is disappointing over and over. Disappointing to see things that should really impact the case not. Trust me. Nobody could be as disappointed as me. But that's that. So anyway, here Vic provided no evidence that Markey or Rial were employees of Funimation. I don't think that's true. Much less they were acting with the course and scope of any employment or agency relationship when they published any of the communications at issue here. Because Markey and Rial are in fact independent contractors, this is a legal question, not a fact question. Funimation is insulated from liability for the tortious acts. In his brief, Vic argues that Funimation retained some control over Rial's work because Funimation allegedly controls when and how she performed her job as a voice actor, that she used her Twitter account for her job, and that she sought Funimation's approval of what she could say in the public arena. No evidence except this. No evidence except this evidence. Vic goes on to argue without any evidentiary support that Funimation must have also had some control over Jamie Markey's work in her social media postings because Markey was also a voice actor who worked for Funimation. Yeah. Yeah. You do. You do. I wish I'd gotten that email earlier. Vic's argument should be rejected. Why? The course and scope element arises only if the tortious act falls within the scope of employee's general authority in furtherance of the employee's business, employer's business, and for the accomplishment of the object for which employee was hired. And the act must be of the same general nature as the conduct authorized or incidental to the conduct authorized. The fact that Funimation may have directed Rial and Markey's voice acting work, which they performed as independent contractors, does not equate to supervisory liability for what they posted on their personal social media accounts. Except he also said you have control over their social media accounts. Judge Chupp, I do not think she was acting in the course and scope anyway, tweeting bad stuff. Well, that's great, Judge Chupp. That's not a ruling on that. Moreover, the fact that Rial testified that she used her Twitter account for her job as a voice actor. God fucking damn it. She testified to using her Twitter for her job. No evidence. I mean, she testified to it, but no evidence. This is what they do. I'm gonna drink this engine cleaner beet vodka made from sugar beets. Y'all want to know why people hate the legal system? It's garbage like this. It's garbage like this. There's no evidence that any of this happened. I mean, well, she testified that she used her Twitter for work. But her job doesn't say defame him, bro. That's a fact question. And it doesn't matter. Her job, of course, does not say to do the illegal thing. You know what? A trucker, a semi-truck driver, who's driving down a highway. Okay? All right, you with me? UPS guy, an employee, not an independent contractor. We'll go with a full-on employee, UPS truck driver. Driving down the highway. Smashes into an SUV, just running over and mangling the bodies of 5 children. Okay? Just kills a whole family. Look, he uses the truck for work, but his work doesn't involve flattening children with the fucking tires. Not vicarious liability, bro. Try it. Try that argument. The fact that they're doing a tortious act obviously isn't part of their job scope when they're doing the thing within the course of their business. It's the fact that she tweets for work, making announcements and appearances on behalf of Funimation, show announcements, encouraging fans to watch a particular thing where she voices some child who's going to be raped in their show, right? Oh, but she's a 700-year-old vampire, bro. I get it. Got it. The fact that Monica uses her Twitter to announce whatever lolly shit Funimation has put out that she's voiced, goes ahead and puts business matters involving Funimation and its other employees well within the scope of the employer-employee relationship and subject to the control. And the fact that she then went to commit a tortious act against someone else in the damn industry who is another employee or contractor or whatever you want to call them of Funimation puts it squarely within the goddamn job duties that she's talking about. She's talking about Funimation's business on her Twitter, which she uses to talk about Funimation's fucking business. Of course it's within the scope of her employment. And no, you probably won't find a clause in her contract that says you must defame your fellow coworkers. Fucking obviously. This is why everybody hates lawyers and judges, because it's obviously bullshit. I drive my car for work, but my job doesn't tell me to run a stop sign and plow into a family. Well, duh. Would she perform for multiple anime dubbing studios? Yeah, she might be an employee of all of them. Does not support any inference that Funimation control what she posted about on Twitter about Vic or on any other subject. Scott Barreto, your guy, admits that you monitor everything said about Funimation and its contractors on Twitter. That you literally monitor all of it. Why, Scott, would you monitor everything said about Funimation, especially by your contractors that you definitely don't control? Why? Why would you do that? Might they be risking the breach of one of the non-disclosure agreements that Funimation might have by releasing the information that maybe they voiced a role that Funimation hasn't solidified a contract with? Might they accidentally do that, Scott? Or might there be some time when you guys say, hey, probably don't want to tweet that. That might be against your contract. I don't know. Maybe. Kaki Onsai says, so if you can clear this up for me, do we have a Schrodinger's amended petition situation? Yep. Seeing the first petition and the second AP both mentioned in all three responses. So which petition would the COA would use? It should legally operative be the most recent petition that is admitted to the court. If Chup didn't strike the second amended petition, the legally operative petition is the second amended petition, period. That's just how it is. He doesn't get to just ignore it. He doesn't get to not consider it. He doesn't get to do those things. He has to either admit it or strike it, and then it is the legally operative petition. He didn't strike it, ever. Trying to use weasel words. Those weasel words are not clear and unambiguous. Shouldn't be a strike. If the Court of Appeals determines that he didn't strike it, second amended petition is operative. If the Court of Appeals determined that he did strike it, first amended petition is operative. That's it. That's the answer. But it is Schrodinger. We don't know which one it will be. There's no way to tell. It's up to the Court of Appeals. In any event, Rial herself testified that she worked for Funimation on a contract basis and does not represent Funimation. Well, la-dee-da. She said she doesn't. I mean, if she said she did, we would fire her immediately. She'd never work again. But she said she doesn't, bro. Ah! Beet vodka is trash. Imagine you're me. Imagine you're me and you're drinking vodka, and that vodka tastes like beets. That's where I am right now. Gay and Still at Large says, Rackets, we need some legal advice on your conduct. Are you sure that rant was legal? Because after the 13th Amendment, I don't think you're allowed to own ninjas like that. Look, you guys will see tomorrow just how much of my activity is legal. You guys will have a new understanding of the risks that I am taking for you. Come to you every night. To lay it out there in public. To put into public what little fucking weasels want private. To put into public what woman-beating, child-threatening assholes want private and silent. You will see. You'll see just what I'm risking, because apparently it's a lot. I'm risking a lot. If you only knew how many things this abusive little marmot was monitoring all of it, and he knows. Guys, you're going to see just how smart he is tomorrow. So smart. Tomorrow he's got it figured out. Wait till you see just how smart Ron Toye is. He knows me. He has got it. And he has got it figured the fuck out. And by the way, Law Twitter, Ron Toye calling y'all out because you got no idea what's going on. He's got it figured out. He's the smartest motherfucker among all of y'all. You have no idea. He knows. He knows. You think the grift is real? The grift is real. Is real. Is real. Shalom, my friends. Further, the fact that Rial asked Funimation for advice about how to deal with the mounting social media pressure about Vic does not show that Funimation had the right to control the progress, details, and methods of what Rial posted on Twitter about Vic. What can I say? Andrew Binns, episode 10, Coomslayer versus Roncubus. Our bodies are ready. See Limestone Products. The test to determine whether a worker is an employee rather than an independent contractor is whether the employer has a right to control the progress, details, and methods of operations of the work. Hey, dumbass. Hey, Volney. Listen. Monica Rial testified that Funimation has no control over her Twitter account. But she asked what she has permission to say on Twitter about it. Think about it, bro. The court should also reject Vic's argument. Look at this. Look at this. The court should just reject arguments. The Funimation's silence somehow communicated its affirmance of Monica Rial's apparent authority to speak on Funimation's behalf. As this court has recognized, it has been said that silence speaks volumes, but the truth about silence is that no one truly knows what it means. It invites speculation, and our Supreme Court has recognized that speculation is not evidence. Except that your guy, your boy, your homegirl, Scott Barreto, flat out said that you monitor all of the communication. And therefore, you would know about it. That's the difference between silence. It's no longer speculation. Scott Barreto knows about all of the communication. By his own testimony, they monitor all of it. And then Monica Rial is expecting you to exercise control over her Twitter. She puts it in an email. It's beyond speculation. We now have a rational inference that Funimation controls the Twitter accounts of its voice actors. At least to some measure. At least to some measure. Vic's evidence that Rial asked Funimation for advice about how to deal with social media pressure was a series of email communications between Funimation and Rial that Vic attached to a second amended petition. Judge Shupp refused to consider the emails because Vic filed them after the parties agreed upon deadline for Vic's response. Accordingly, the court should disregard Vic's argument. So here again, we have the underlying and ultimate question for the appeals court. We have evidence on file in the clerk's record and presented to the trial court that we must reject arguments based on the existence of this evidence, which impliedly states if this evidence comes in, we have a valid argument or a fact problem that needs to be resolved. So now we have to determine, as I've said over and over and over again, does the exclusion of this evidence by an operation of procedure provide a just and equitable outcome for both parties? Worded differently, does the exclusion of this evidence make a lawsuit without merit? And would, conversely, the inclusion of the evidence grant merit to an otherwise meritless claim? If it does, the TCPA's purpose demands that it allow the evidence because the TCPA is not intended to deny otherwise meritorious claims, only meritless ones. Their entire position is operating on the idea that we should procedurally remove the merit from the case so that it becomes meritless, not that the case is without merit. And that might be the needle tip on the scale. That might be it. We'll have to see. This is not a case like the one Vic cites, Pan American Operating Inc. versus Maud Smith Estate, where other conduct from the principal in the case clothed the agent in indicia of authority, and thus the principal's silence was, in effect, a manifestation that its agent had authority. Why not? Why not? Here's a question for you guys. Does the average person out there running around watching anime, the people on February 11th, 2019, does anybody on Twitter know that Monica Rial is an independent contractor versus an employee? Or do they think that Monica Rial is speaking on behalf of Funimation? There you go. What's a reasonable person think? What's the everyman think? They all think she's an employee of Funimation because they all think Vic's an employee of Funimation because Funimation just fucking said, we're firing a guy that we work with. And most people would say, damn, those are Funimation employees and they just lost one. The Pan American Court described that case as one where the principal had a formal business relationship with its agent, knew its agent would be contacting third parties on its behalf for the express purpose of carrying out its business objectives, promoting shows on Twitter. By the way, posting on Twitter is contacting third parties on behalf to further business experiences. Hey, come watch me. Come watch me voice a lollybait. Come watch me voice a lollybait rape victim. And outfitted the agent with the tools necessary to accomplish his task. Blue check mark, Twitter, bunch of acting credits, Funimation sponsored convention appearances, those types of things. Those things that would lend credibility. I don't know. Including an email account, a cubicle in the office, and a company landline to use to obtain business on the principal's behalf. Oh, see, now we're going to distinguish between a salesperson and a voice actor. What about a microphone, a booth, an ADR director, lines to say, a time to show up, recording studio time, an audio engineer, promotional artwork? What is it? Are they not providing something? I don't know. Thus, the Pan American Court that the principal clothed the agent with the indicia of authority he purported to have and on which the third party relied by knowingly failing to take any action to dissuade the third party from believing the agent had the authority to bind. That last sentence right there. knowingly failing to take any action to dissuade the third party from believing the agent had the authority to bind. What was Funimation's second tweet, by the way? Funimation does not condone harassment or abuse of any kind. Are they condoning harassment? How are they not condoning harassment or abuse? What authority do they have to not condone it? Or to condone it otherwise? Maybe it's the beat liquor drinking. Maybe it's the beat liquor talking. But I would suggest if you said that Funimation doesn't condone or promote or whatever harassment of any kind, you're giving people the idea that you have the authority to condone or not condone it. And therefore that your agents are under that thing. You don't tolerate it. What are you going to do? Several people asked Funimation to discipline Monica Rial for her statements, by the way. Very weird. This case is easily distinguishable. Vic provided no evidence that Rial had actual authority to tweet on Funimation's behalf, well, except for her testimony. In fact, she has no such authority. That's a fact question. It's resolved in favor of Vic. Rial was not Funimation's agent or employee. That's a mixed question of fact and law. Funimation had no control over what she posted on social media, contrary to her email, contrary to what she testified. Noting that it was undisputed the agent in that case had the authority to execute oil and gas leases and negotiate terms on the principal's behalf. Yeah, that's a lot of stuff, but you don't have to have that much. Nor did Vic present any evidence that Funimation took any steps to clothe Rial with authority to speak on Funimation's behalf about Vic. Oh, now we're really specific. Now it's only about Vic. Sure. Because Vic failed to present any evidence either that Funimation knowingly permitted Rial to hold herself out as having authority to speak on Funimation's behalf, or Funimation acted with such a lack of ordinary care so as to clothe Rial with indicia of authority, Vic's apparent authority argument fails. Vic cites other cases, but they do not support his apparent authority argument because they involved undisputed employer-employee relationships where the employees were acting within the course and scope of their relationship. Oh, trust me, this one's undisputed too. Unlike the Associate Dean in Lavery versus Weatherby, Rial was neither Funimation's employee nor had the job duties on behalf of Funimation to publish allegedly defamatory statements about Vic. Notice how they're trying to narrow the issue. Just to publish defamatory things about Vic. Authority to do everything else, just not that one. Considering whether government employee was immune from suit under Texas Tort Claims Act because allegedly defamatory statements were made within the course and scope of her job duties. Rial was not acting within the course and scope of her employment with Funimation when she communicated about Vic in her personal social media account, except that she referenced specifically internal investigations that were meant to be private. Except for mentioning explicitly private communications about an employee issue within Funimation with the apparent authority of doing so as an employee of Funimation. Except for that, they're right. Does anybody know how to do yoga? I think I need to do yoga. Hooper versus Pitney Bowes, Inc., noting that local and regional managers did act within their course of employment because their secret meeting benefited their employer. You mean the secret investigation? The secret investigation? The one that was confidential, that wasn't supposed to be talked about, but fat ass Rial somehow managed to get words around those ugly ass veneers. That one? That secret meeting? Finally, Rial was not acting within the course and scope of any employment relationship, unlike the Saginaw police officers who testified at trial in Dellon versus Villarreal. Remainder of Vic's vicarious liability argument reads more like a closing argument than a clear explanation of why Funimation should be held liable for what a couple independent contractor voice actors published on their personal Twitter accounts. Because Vic failed to meet his evidentiary burden, the trial court made the right decision to dismiss Vic's vicarious liability theory against Funimation. Trial court properly dismissed Vic's conspiracy claim against Funimation. Vic next argues that the TCPA does not apply to his conspiracy claim and that he otherwise presented a prima facie case of the elements of that claim. Court should reject Vic's argument. The conspiracy claim fails as a matter of law if the underlying claim has failed. Observing that the jury's finding on conspiracy are only relevant if we find in Appellee's favor on one of the other tort theories pleaded, holding that because Appellee failed to establish any other substantive tort, there is no independent liability for conspiracy. If you don't understand how this argument is working, this argument is that if any of the causes of action survive through appeals, conspiracy must also survive and cannot be TCPA'd independently. As conspiracy rests on an underlying tort, the ability to TCPA conspiracy should rest on an underlying tort is the argument. Not saying it's correct, although it's a good one, but that's what they're really going for here. You can't separately reject the TCPA claim. There's no, or separately reject the conspiracy claim. And there's no real argument here that Chup did. Because if the Chup rejected the conspiracy claim because none of the other torts survive TCPA. That's the main goal or the main idea here and the main problem. He didn't have to consider conspiracy because he didn't allow any of the torts through. Observing that the jury, because the trial court properly dismissed Vic's claims against Funimation for defamation, TI with existing and prospective contracts and vicarious liability, Vic's conspiracy claim also fails as a matter of law. Sure, it does. Unless one of those comes back. Christopher French says, between work, Corona-chan, and trying to get a little bit of sleep, I end up falling asleep while listening to you. As far as I know, I don't have COVID-19. I am glad you don't have COVID-19. I'm glad you fall asleep listening to me. Sorry if I yell and scream, but I'm going to do it more. It's just coming. In any event, the court should reject Vic's argument that the TCPA does not apply to his conspiracy claim. Case relied upon by Vic for this argument, Kawak versus Antero Resources Corp, is easily distinguishable from this case and provides no support for Vic's position. Kawak involved a claim for breach of fiduciary duty against a former employee. Based on the former employee's participation in an alleged vendor kickback scheme, when he was sued, the former employee filed a TCPA motion in which he argued that his communications with the kickback-paying vendor were covered by the TCPA's right of association. Fort Worth Court of Appeals rejected this argument. I mean, holding that the common interest covered by the TCPA's right of association requires more than two tortfeasors conspiring to act tortiously for their own selfish benefit. Sounds literally like this case, but case presented here is not about two tortfeasors conspiring to act tortiously for their own selfish benefit. Rather, this case involves an anime studio's public online comments about a public figure whose misconduct had again become a matter of public concern. Funimation's public statements about Vic motivated Vic into filing his slap suit in an effort to suppress Funimation's speech. Nope. No evidence at all that he's filing to suppress speech. Ever. None. Never asked them to be quiet. Never asked them to stop talking about it. As such, this is exactly the type of case the TCPA was intended to address. Baseless litigation that suppresses the sorts of expressive activities that are the essence of self-government. You find me a business lawyer who says that Funimation's tweet was the right thing to do. I will grab your nuts and hold them for 10 minutes. Just kidding. That's not a binding offer. Furthermore, unlike the defendant in Kawak, Funimation did not rely solely on the right of association as its basis for invoking the TCPA. Funimation argued primarily that statements about Vic were an exercise of Funimation's right of free speech, defined as communication made in connection with a matter of public concern, including issues related to health or safety, community well-being, or a public figure. This is a fucking lie. The only thing they have is maybe a public figure. They don't comment at all on a matter of public concern or community well-being, or health and safety. Just by calling it the Vic situation doesn't make it a matter of public concern. As such, Cowick's narrow analysis of the right of association in the context of a commercial dispute does not apply. Funimation was exercising its right of free speech when it published tweets about Vic. In any event, Funimation presented evidence that it was exercising its right of association when it tweeted about Vic. Funimation's tweets, which were addressed to the anime community in general, clearly qualified as communications between individuals who joined together to collectively express, promote, or pursue or defend common interests. What common interest is we're firing someone? Someone explained to me we are no longer working with someone due to an internal investigation about harassment. You tell me what common interest they have with the anime community. What is it? Funimation's first tweet was addressed to everyone in the anime community interested in the Vic Mignogna situation, which was a matter of common public interest and concern in the anime community at the time. The second tweet expressly referenced the anime community, Funimation's love for the genre, and its positive impact on all. That's a fact question, by the way. Those two things are fact questions. Accordingly, because Funimation was exercising its right of association with the anime community by tweeting about the Vic Mignogna situation, by discussing its core mission within the anime community, and by sharing its love for the genre, Funimation was clearly exercising its right to associate with the anime community regarding their common interests. Sure. Finally, Vic failed to support the elements of its conspiracy claim with clear and specific evidence, which further justified dismissal of the claim in his brief. Instead of pointing to direct or circumstantial evidence that appellees reached a meeting of the minds on a course of action to defame Vic, and then took one or more overt acts in pursuit of that course of action and thereby approximately caused Vic damages, Vic asked his court to make multiple reasonable inferences. That's what you need for TCPA, by the way. Rational inference. Based on Vic's one-sided reading of the facts. Holy shit. Yes. Good line. Actually, if I were the plaintiff, I would use this line. The appellant. I would use this line. Yes. We are asking the court to, based on the plaintiff's reading of the facts, find rational inferences, which is the minimum quantum of evidence required to support a TCPA. Well, a minimum quantum of evidence required to support a rational inference of a cause of action. That's it. That's it. They've actually stated in this line the specific, basically the specific thing to pass a prima facie showing. So yes, Vic is asking them to make a rational inference based on the plaintiff-favored reading of the facts, which is the standard for prima facie. It's right there. This is similar to Vic's arguments at the TCPA hearing, where Judge Shupp criticized Vic's counsel for his heavy reliance on rational inferences to support the elements of Vic's claims. That's the standard. Judge Shupp, no, you made a lot of things you think are rational inferences, and they're not. No number of inferences adds up to a conspiracy claim against Funimation, as Vic's strained reading of the evidentiary record shows. I mean, they flat out lay out the standard. It's a case law standard. I don't remember the case off the top of my head. It's rife in Vic's brief. You can go find it. That's amazing. I would almost copy and paste this line right here. I would copy and paste this line. Copy and paste it. Absolutely. That's what we're asking the court to do, because that's what the Supreme Court says this court is supposed to do and what the trial court should have done at trial. Period. 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 Done. This should go past TCPA because it's rational inference. For all these reasons, there is no reason for the court to reverse the trial court's dismissal of conspiracy claim. Trial court did not abuse its discretion by refusing to consider Vic's late filed second amended petition and its many attachments. Well, let's see how this goes. Vic further argues that Judge Shupp should have considered Vic's second amended petition and its attachments in deciding whether Vic had met his burden to withstand the party's TCPA motions. Vic's argument should be rejected. Parties agreed pursuant to a Rule 11 that Vic would file his response to the defendant appellee's TCPA motions by August 30th. Vic violated that Rule 11 agreement when he filed his second amended petition with newly signed declarations to substitute for the fraudulently notarized affidavits. Come on, give me the fucking thing. What the? There we go. Oh, wait a minute. Do you guys remember this? Let's go back to this real quick. Ignore the use of specific words with specific meanings. Hi, cat. Mike, you don't by any chance mean words like response and reply, do you? Wait a minute. Does the word response have a specific meaning? Hey, Mike, fat fucking moron Dumford. Does the word response have a specific meaning? Hey, cat, crazy cat lady, apparently. Does the word response have a specific meaning? Maybe you should tell John fucking Volney. Vic would file his response to the defendant / appellee's TCPA motions by August 30th. Is a second amended petition a response to a TCPA motion? Hey, Mike Dumford. Is it? I'll wait. Or does response only have specific meaning when it's convenient? Because, by the way, Mike has argued that the second amended petition, which is not a response to a TCPA motion to dismiss, by the way, is a response to a TCPA motion to dismiss, despite the fact that it's clearly a petition and is in no way structured like a response, not worded like a response, is not called a response, is not in any way a response to a TCPA motion to dismiss. But Mike Dunford has argued that it is. Hey, Mike. When does response have a specific meaning? I mean, of course, he's going to jack off into his mouth and come up with some weird way that doesn't mean what it means here. But it means what it means there. But not here, though. Maybe, just maybe, the defendants should have more clearly, they're fucking lawyers, more clearly worded the Rule 11 agreement if they wanted to be bound to something different than what they fucking put down on paper. Except Mike, he just wants to clearly explain the law, right? You fucking apologist. It's embarrassing. It's embarrassing that you're trying to hide your obvious bias. It's embarrassing. Anyway, pardon my rant. At the hearing, Judge Shep stated on the record he would not consider Vic's second amended petition. That's not actually true. I don't think. Maybe it is. I mean, they're citing to the record. Can I look it up? God damn. Hold on just a second. Third reporter's record, page 42. Just a second. I got it. Let's see. Okay, no. I'll read it verbatim. I was incorrect. It says, yeah, I mean, I'll probably consider the affidavits as far as your response, but not your new pleading, not your second amended petition. That's obviously you're trying to get around the rules. I mean, so I have read them. So, I mean, I know what they say. It's going to be hard for me to put them out of my mind now that I've read them anyway. And then Ty says, yes, Your Honor, you didn't get an accurate copy of the email. Court says, I'm not worried about that. I'm worried about the cause of action that you have against Ms. Markey and the tweets that are in your first amended petition, because that's a petition we're here about, because you didn't file the second amended petition until after you filed the affidavits wrong. So let's deal with that one and tell me what tweets other than the two that you've told me so far. Ty says, then I have to beg the indulgence of the court for just a second because I've got to find the documents. There's actually two documents that are operative, I think, Your Honor, our response and our first amended petition. Okay. So anyway, going on. Notice he doesn't strike it. He still says, I'll probably consider the affidavits as far as your response, but not your new pleading. So again, we've got this weird double issue going on. But that's the weird issue here. So he does say he would not consider Vic's second amended petition. That's still not a ruling, by the way. That's not a ruling. I don't know how else to say that. Not a ruling on the record of what you're considering. Or it's not a ruling of what's in the record. It's just him saying he's not going to consider it. Not really the judge's option to consider something or not. That's not a discretion right there. There we go. In his order memorializing his rulings on the TCPA motions, Judge Shupp questioned the propriety of Vic's late filed second amended petition, stated that he did not consider evidence submitted after the agreed upon deadline in the Rule 11 agreement, with the exception of plaintiff's response to defendant's TCPA motion to dismiss without the withdrawn affidavits, which was deemed timely filed by this order. So again, that's not clear and unambiguous. They're even admitting, look at this. This is great. Judge Shupp questioned the propriety of the late filed second amended petition. That's not a clear and unambiguous ruling on the matter. The judge's job is to provide a clear and unambiguous ruling on the matter, especially because the other side objected to it. Questioning the propriety is not clear and unambiguous. You say, yeah. Thus, Judge Shupp refused to consider Vic's second amended petition and its attachments. Judge Shupp did not abuse his discretion by enforcing the Rule 11 agreement, except that he didn't enforce the Rule 11 agreement against Vic. That's not part of the Rule 11 agreement. Now, this is unfortunate because they have to spend a lot of word count making a distinction between the response and the second amended petition, which is not considered by the Rule 11 agreement at all. Rule 11 agreement specifically considers the response. And then they have to spend word count arguing that the second amended petition is not otherwise in violation of the rules. It's a mess. But either way, they have to do it. Holding that when movement agreed to delay hearing as long as non-movement filed his response at least 1 week before hearing, but non-movement filed a response and affidavit just 1 day before hearing, trial and appellate courts erred in considering the affidavit. This isn't what happened, though. This isn't what happened. They filed the response and affidavits in time, and then they separately filed the second amended petition and the unsworn declarations. Holding that when Rule 11 prerequisites were met, trial court had ministerial duty to grant relief in strict accordance with the parties' agreement. Strict accordance. A response is not an amended petition. Amended pleadings are amended pleadings. Responses to motions are specific documents with a legal meaning behind them. So, again, they're going ahead and laying out the exact reason why Judge Shupp did not rule on this and did not rule properly if he did. Just a second, guys. I got to take care of something. I'll be right back. All right, all right. Sorry about that. Sometimes, man. Sometimes. Okay. Where were we? So again, strict accordance with the parties' agreement is a line that goes absolutely against everybody's assertions in this matter. It should be enforced in strict accordance with the agreement, which is one of a response, not a petition. Thus, it was neither arbitrary nor unreasonable for Judge Shupp to exclude from consideration Vic's second amended petition and the evidence that Vic attached to it. How? How is it not arbitrary or unreasonable if you're doing a strict accordance with the agreement, which specifically mentions a response to the motion? That's it. It's a response to the motion. That's what's considered. That's what's in the record. I wonder what's in the transcript of that hearing. I think I have it somewhere. I'll have to check. Moreover, the TCPA's direction that the trial court should consider the pleadings in supporting and opposing affidavits does not provide a litigant carte blanche to submit evidence by attaching it to a late filed petition. Texas Rule of Civil Procedure 59 precludes a party from attaching purely evidentiary matters to a pleading. See, this is a problem because the pleading is evidentiary. The pleading is evidence in a TCPA matter. Rule 59 prohibits Vic from attaching declarations, tweets, emails, and timelines to his petition to circumvent his failure to file a timely TCPA response with properly notarized affidavits and with all the intended attachments. Again, he made a trial amendment, and they haven't really addressed the trial amendment in any of their documents, probably because it would make a mess. While Judge Shupp did not cite Rule 59 as a basis for refusing to consider the attachments to Vic's second amended petition, hey, here's a problem. Oh, the rule was raised at the TCPA hearing as a basis for excluding Vic's late filed evidence, except he didn't rule. They flat out say he didn't rule on it, and provides an additional reason why the trial court's ruling was correct with respect to the attachments to Vic's second amended petition. They objected to the petition. He didn't rule on the objection. They didn't secure a ruling on the objection, especially not based on Rule 59. Should be in. Should be in. In his brief, Vic tries to shift the burden to Funimation and the other appellees to show they were not surprised or prejudiced by Vic's amendment, but the prejudice to Funimation is evident. Is it? Vic failed to file a timely, complete response to Funimation's TCPA motion supported by properly notarized affidavits, even after all appellees agreed to continue the TCPA hearing to allow him additional time to respond. Except he filed a timely, complete response, which he's not required to do, by the way. He filed a response. He just didn't file an amended petition, which he can do. Further, as discussed at the TCPA hearing, Vic's second amended petition contained new allegations that Vic had not included in his prior pleading, along with new evidence that Vic had failed to include with his response. Allowing Vic to escape his agreement prejudices Funimation. Again, that's not in the agreement. Now, if they want to have an argument about surprise, they should be required to make the argument about surprise in the petition. The problem is, there's not really new stuff in the petition. Not really. For these reasons, it's better organized. I know there are new paragraphs. I get it. New stuff? What new stuff? Haven't been very clear about what it is. For these reasons, the trial court did not abuse its discretion by refusing to consider Vic's second amended petition and its attachments. Let's see. Trial court did not abuse its discretion by overruling Vic's objections to the affidavits and other evidence submitted by Funimation. This is an interesting one because they actually did object and got a ruling on these. So these will be considered kind of properly as abuse of discretion. Next, Vic rehashes objections that he made to the affidavits that Funimation submitted in support of its TCPA motion. Court reviews the trial court's evidentiary rulings, such as a ruling on a motion to strike an affidavit, for an abuse of discretion. The trial court abuses its discretion if the court acts without reference to any guiding rules or principles, that is, if the act is arbitrary or unreasonable. Because the trial court denied Vic's objections, Vic argues that the trial court's findings, Vic is a public figure and that Funimation's tweets related to public controversy and therefore the Tcpa applied to Vic's claims against Funimation were based on inadmissible evidence and therefore constitute reversible error. Vic's argument should be rejected. Let's see. In his order, Judge Shupp relied on the allegations contained in Vic's first amended petition as well as the evidence submitted by all defendants' appellees to justify his finding that Vic is a public figure as contemplated by Texas defamation law, which means that if any single piece of this should have been properly considered, the appeals court needs to take a second look at that public figure ruling, because that would mean that Judge Shupp relied on evidence that was improperly admitted. I'm not saying he did. I'm saying that if that's the case, if any single piece should have been inadmissible, then they have to look back at it and say, was this ruling, the initial ruling, proper? Because if the ruling was based on impermissible evidence, then it can't be there. That's an abuse of discretion. So, as an initial matter, regardless of the trial court's ruling on Vic's evidentiary objections, more than enough evidence in the trial court's record to establish that Vic is a public figure and that Funimation's tweets relate to a matter of public concern. See, this is what what I was just talking about. If they can show that, if they can show that some of the evidence should have been excluded, now we have a problem. So they're trying to head off that problem. Look, even if you exclude the other evidence, then there's more than enough, though. So that's what they're going for here. A public figure is a person with general fame or notoriety in the community. Gertz versus Welch. Vic is a public figure because he held himself out as a person with general fame as shown by his deposition and by his petition in the case. Again, general purpose public figure, Vic is not. Vic just isn't. He just isn't one. I don't know how else to say it. Even in the anime community, people don't know who Vic is. Like, just generally. If you go to 10 anime viewers and you ask all of them who Vic is, you might get one or two who know who he is. That's it. Now, if you get they should have said the convention community or something. But I don't think they ever made this argument. Vic is over 20 years in the entertainment industry and has appeared in movies, television shows, and hundreds of Japanese anime films. Not a general purpose public figure in any way, by the way. Lots of people you have never heard of qualify for this. Let's see. Vic has amassed a fervent fan base and has his own official fan club. Yes. That's not the community. That's his specific community. We're not talking about the Risen Bull Rangers here. We're talking about anime entertainment, apparently bigger than anime, right? More than anime. Vic was the voice actor of the character Broly in the financially successful film Dragon Ball Super. Look, judges, I know you've never heard of Dragon Ball or Broly or this movie, but trust me, he's a general purpose public figure. Or Funimation. You've never even heard of anime, so much so that we have to actually explain it to you. But trust me, everybody knows who he is. Vic makes money by making public appearances at 35 to 40 fan conventions per year. Again, this isn't a general purpose public figure. This maybe is a limited purpose public figure argument, but that would require him to then participate in that limited purpose for the purpose of defending himself and exerting his influence in that community. They could actually make that argument. Vic may be a limited purpose public figure. He is certainly not a general purpose public figure. Question should be, whether or not the court will take it this way, is, was Vic a limited purpose public figure on a preponderance of the evidence brought to trial? Maybe he is. He might be. I'm not denying it. I think his apologies are mistakes, and they may, by themselves, be enough participation. Those apologies, I can't express it enough. Don't apologize. He also did some panel appearances in which he, made some statements about it. Don't do it. Don't do that. Those things may have made him a limited purpose public figure. Whether or not they're properly before the court will be another question. frankly, I think they're going to win on the public figure argument ultimately. I do. As a limited purpose public figure, just because it's never an automatic yes, but there's a lot to say that he might be. Even if they don't, for the purposes of TCPA, later I think they'll win when they introduce other evidence. That's just me. That's just where I am right now. I think they may end up doing that. But for the purposes of TCPA, I don't know that they met their burden. And it's their burden. And again, this is an automatic win for them, so the burden should be heavy. So, Vic has a robust social media presence, as he admitted in his filings with the trial court. The allegations surrounding Vic garnered widespread media attention from multiple media outlets. That's not him, and that is not a limited purpose public figure. And a robust social media presence, yeah, so does Destiny. And literally no one who's not on the internet fucking cares. Go ask your grandparents, hey, do you guys know about a little 5'3" manlet named Destiny? Do you guys know about that guy? He likes watching his girlfriend get railed by better men. But she comes home to him at night, so it's okay. Have you ever heard of him? He doesn't love black people either. You guys ever heard of Destiny? Go ask your parents and grandparents if they've ever heard of Destiny. You're like, wait, you mean like what that guy said in Back to the Future? No, I mean a squirrely little halfling that likes watching his girlfriend get plowed by other men so long as she comes home at night. That one. No one knows who he is. What's Destiny's Twitch? Just a second. We can solve this problem immediately. Destiny has 536,000 followers on Twitch. 5 times Vic's social media presence at the time of the suit. 5 times. Let me make that clear. Destiny, whom most people will have no idea who he is or care, has 5 times as many Twitch followers as Vic has Twitter followers, and Twitch followers are harder to get than Twitter followers. You convince a judge that Destiny is a general purpose public figure. Anyway. Oh, and Destiny, by the way, they write about him in Vice. So he gets widespread media attention from multiple media outlets too. Vice and others. I don't know the other ones. And still, most people have never heard of him. Because in the era of social media, 100,000 people who know your name sounds like a lot, but it's not that many in the grand scheme of things. This evidence more than established that Vic is a public figure and that Funimation's tweets about Vic were a matter of public concern. This is a problem with defamation law generally, and it is a struggle that will be worked out over the next decade. And yes, the courts are that slow. But how many followers makes a public figure? It's really a question. Is it 100,000? If that's 100,000, it's a low bar. You got titty streamers with 300, 400,000 people and you've never seen their face. All you see is neck down, right? Like that's just how it goes. Is Alinity a public figure? 1.1 million followers on Alinity? Judges watch Alinity stream? They ever heard of a person named Alinity? These general public figures? I don't know. The court doesn't either. Anyway, back to it. And they cite Lane versus Ferris. Finding opera singer was a public figure. Well, that's a pretty fucking... This is a limited purpose public figure argument in Lane versus Ferris. So this is a pretty weak explanation of that citation. Johnson versus Southwest Newspaper Corp. Finding an athletic director, head football coach, and a classroom teacher at 130 student school was a public figure. What did he do to participate in his matter of public concern? Probably a limited purpose public figure argument as well. Blaine 20 says there are multiple strains in the U.S. Treatment of New York strain fails on New Orleans strain, for example. Healthy 30 to 50 people are targeted by one strain, elderly by another. Testing in my area is taking 10 days, not 3 to 4 like other areas. Oi. Oh, good luck. Judge Chupp properly overruled Vic's objections to the affidavit of Funimation's Vice President of Operations, Karen Mika. Wow. Judge Chupp made the correct evidentiary rulings in any event. Contrary to Vic's arguments, Funimation's officer Karen Mika adequately explained the basis for her personal knowledge about her dealings with Vic and Funimation's other independent contractor voice actors. Under the law, corporate employees generally presumed to possess personal knowledge of facts that he or she would learn in the usual course of employment without having to otherwise prove personal knowledge. Mika explained she is vice president of operations of Funimation. As a result, she is familiar with Funimation's business practices and its business relationships with its employees and its independent contractors. Mika also recounted her specific communications with Vic. On the call, I informed Mr. Mignana that his conduct was unacceptable to Funimation, that Funimation was terminating contract with him immediately. Thus, the facts stated in her affidavit were sufficient to show that Mika was competent to testify. Again, that'll be a question for the appeals court. Funimation also submitted a supplemental affidavit from Mika that provided more details about her job responsibilities at Funimation, which further proved her competency to testify. Except she didn't do that in her first one. So interestingly, they should argue that she tacitly admitted that it wasn't sufficient and that Chup improperly included it. That's what I would go with here. Now look, Chup may have properly included the second affidavit, but they've just gone ahead and said that they didn't think that the first affidavit was sufficient and that it shouldn't have been included. Like they've implied this. Now, they're not actually implying this, but you say they're implying this because it kind of looks like they're implying this, and they absolutely were. Why do you think they added a second amended, or that they added an amended affidavit with a boned up response? Why? Because the first one was good enough? Come on now. Back to it. In addition, Judge Chup properly overruled Vic's hearsay and best evidence objections to Mika's affidavit. Mika's testimony about the allegations on social media of inappropriate conduct against Vic was not being offered for the allegations' truth. Well, that's interesting. But were instead offered to show the reason for Mika's request for an investigation of Vic's alleged misconduct and to show that Vic is a public figure whose misconduct was a matter of public concern. Oh, was it? That said, Vic freely admitted the facts stated in Mika's affidavit during his deposition and in his petition, so the trial court's ruling could not have resulted in reversible error. Oh, that's not true. Question. On January 16th was the date of the latest Broly movie release. Yes, sir. In theaters. And that was the same date these types of social media posts started to happen that were accusing you of inappropriate behavior. Yes, sir. Yeah, those are fine. Those don't mean you get to admit everything Karen Mika said. That's weird. That's a weird flex. Last, Vic argues that Judge Chup should have sustained his objection to paragraph 9 of Mika's affidavit, which provided it follows. Funimation is not responsible for any tweets or other social media publications or commentary by co-defendants Monica Rial, Jamie Markey, or Ron Toye. Funimation does not have any control over what Markey, Rial, or Toye publish on their personal Twitter accounts or in other social media. This is actually, at least in regards to Markey and Rial, this is perjury. This is flatly perjury. Rial and Markey are not employees or agents of Funimation. They do not have actual or apparent authority to speak on behalf of Funimation. That's a legal question. Vic and the other voice actors who work for Funimation, including Rial and Markey, are independent contractors, and Funimation does not hold any of these voice actors out as its employee or agent. Legal question. For his part, Toye is the fiance of Monica Rial. Toye is not an employee or agent of Funimation, has no relationship whatsoever with Funimation. Vic argues that Mika's statements about Funimation's business relationship with its voice actors, Rial and Markey, and its lack of any relationship with Toye were legal conclusions that Judge Chup should have excluded from evidence. Yeah. Judge Chup properly overruled Vic's objections. Vic cites to a bevy of cases that do not support his argument that Mika's testimony should have been excluded. Lemon versus State does not involve any issue remotely akin to the issue present here. That case involved whether a house guest had the actual or apparent authority to consent to a police search of a home. Needless to say, actual or apparent authority to consent to a warrantless search of a home is different inquiry from actual or apparent authority to use Twitter on behalf of a company. Except, remember, Monica's testimony says that she tweets as part of her job with Funimation. Flat out. Again, we have a fact issue that should weigh in favor of Vic. Now, they may overcome it at trial, but that's for the trial court. Vic's other cases actually support Funimation's position by making it clear that Funimation had no duty to control the conduct of third persons unless a special relationship existed which imposed a duty upon the actor to control the third person's conduct. Special relationships include the relationship between employer and employee, which he's argued, parent and child, an independent contractor, and contractee under special circumstances, noting the contractee may be liable for an independent contractor's conduct when he retains the right to control the contractor's work, which Monica Rial has testified to and was included in the email. So again, no special relationship existed in the instant action. That's a fact question. While the existence of a legal duty is a question of law for the court to decide, court must make the decision based on the facts surrounding the occurrence in question. Accordingly, Vic's cited cases justified allowing Mika to testify about Funimation's business relationship with his voice actor so that Judge Shep would have facts on which to base his legal determination. Except she didn't make factual assertions, she made legal conclusions. And that goes to the problem with the argument. It was legally conclusory. She said they don't have it. She didn't say why. She didn't talk about the facts surrounding their employment. She just said that they aren't. Those are legal conclusions. They've actually made a problem with the argument here. And again, who knows how much word count they're going to give to all of this, but they've just made the case here that remember, Vic's objection is that about Funimation's business relationship with his voice actors were legal conclusions that Judge Shep should have excluded. And then they say that facts surrounding the occurrence in question would have facts on which to base his legal determination. Except he didn't argue that it lacked facts. He argued that they were legal conclusions entirely. So they'll have to hammer back on this. Mika's statements about Funimation's business relationship with Rial and Markey are further supported by her supplemental affidavit, which include copies of the independent contractor agreements between Funimation and Rial and Markey, as well as Rial's deposition testimony. Judge Shep properly overruled Vic's objections to the affidavit of Sony Pictures Entertainment Executive Director of Employee Relations, Tammy Denbo. Vic objected that Denbo is not competent to offer the following testimony. My investigation began. There were allegations on social media that Mr. Mignogna had engaged in appropriate conduct with female fans at anime conventions. Vic contended that Denbo lacked personal knowledge to allow her to make this statement, and the statement was inadmissible hearsay. Judge Shep properly overruled his objections. Denbo's testimony was not being offered to show that the allegations reported on social media of inappropriate conduct by Vic were true, and she instead offered the testimony to show the impetus behind her investigation of Vic's alleged misconduct. I think they were arguing that the existence of the information is why that she didn't properly lay the foundation for her hearsay, but maybe not. I don't remember. She instead, as such, the hearsay rule does not apply. As for her personal knowledge, Denbo explained in her affidavit that she performed scores of investigations for employer Sony Pictures Entertainment and had subsidiaries on an annual basis, including her investigation of Vic, which would qualify her to offer testimony that there were such allegations against Vic on social media under Texas Rule of Evidence. Judge Shep properly overruled for Scott Barreto. Finally, Judge Shep properly overruled Vic's hearsay objections to Scott Barreto's affidavit. The out-of-court statements recounted in paragraphs 5 and 6 of Barreto's affidavit were not inadmissible hearsay because those statements were not being offered for the truth of the matter asserted, but instead to show that Vic is a public figure and that his conduct was a matter of public concern. This isn't true at all. Let's see. Rejecting hearsay objections to media statements offered as public figure evidence in a defamation case. Vic also complains that Barreto did not have personal knowledge sufficient to authenticate the publications attached to his affidavit, which include several online publications. That's because he didn't actually do it. About Vic and the allegations of misconduct, Vic's tweets in response to the public firestorm surrounding him. Judge Shep properly overruled Vic's authenticity objections for two reasons. First, testimony from a witness with knowledge such as that provided by Barreto is more than sufficient to meet the threshold for authentication under Rule of Evidence 901B1. In his affidavit, Barreto testified that he monitors media and social media posts related to Funimation. This isn't good enough. This is just general knowledge of monitoring it. It doesn't have specific knowledge of any of the evidence claimed, which qualified Barreto to authenticate the articles and social media posts attached to Funimation's Tcpa motion. He doesn't actually state that he has personal knowledge about those things. That's the problem with it. In his supplemental affidavit, Barreto further testified that he regularly and actively monitors print and online media related to Funimation's business, including by regularly checking online publications and media outlets such as those that publish the articles, the online articles that he authenticates. Oh, wow, that's convenient, isn't it? Again, they're admitting that The first one wasn't sufficient. They're implying that it wasn't sufficient based on what they provided. And it still doesn't state, well, I think the second one does state that he personally verified these things on these dates. But the first one doesn't. So, did Chup include evidence improperly? I think so. Do they argue that the first ones were improper? Yeah, they do. They do. In his affidavit, Barreto testified, because this testimony from a witness with knowledge authenticates the news articles and tweets attached. This is actually a really weak argument. They should have done better here. Because he doesn't testify to personal knowledge of these things. Look, I monitor social media all the time. Now, can I verify a tweet from 6 months ago from Keemstar? No. Not unless I go look at it, click on it, verify it myself as of today with the correct date, and make sure there was no edit in place. I can't verify that. I don't know what someone tweeted 6 months ago without going and checking, without checking an archive link, without anything. Second, the online media articles attached to Funimation's Tcpa motion were self-authenticating under Rule of Evidence 9026, which provides that no extrinsic evidence of authenticity is required for printed material purported to be a newspaper or periodical. Uh-oh! It's not printed, though. And online articles can be updated constantly, so they can go ahead and argue against this. Because the articles were self-authenticating, Judge Shep was correct to overrule Vic's objection. These weren't printed articles, and we don't know what date they were pulled on. We don't know if they were modified from the original date. This is a problematic and weak argument. Here, this is bad. They should have done better here. They can't verify that these things said what they said at the time that Scott Barreto read them. They can't even verify that Scott Barreto read them prior to making his affidavit. They can't do it. And they should have argued that he could, but they can't. Judge Chup also properly overruled Vic's hearsay objections to Barreto's affidavit. Vic's own tweets attached as exhibits DJ and N to Funimation's TCPA motion were not hearsay because they are party admissions. The online articles attached to Funimation's TCPA motion were not inadmissible because those articles were not being offered for the truth. Those articles were offered to show that Vic is a public figure due to media frenzy surrounding him. They'll have to go back into why they included them in their motion and make sure that this is true. I don't know. Out-of-court statements are not hearsay if they are offered for a purpose other than to prove the truth of the matter asserted. Thus, when a party offers a statement simply to show that it was made rather than to show its truth or falsity, the hearsay rule does not preclude its admission. Except that they're showing that Tammy Denbo relied on those statements. Actually, they argue that in this. If I remember right, Funimation actually makes the argument that Vic was fired based on, follow me, not only the investigation, but also public statements made online. I swear I remember that line specifically earlier in this document. I'll have to go back and find it. But if they said that, they defeat their own hearsay objection, at least as far as Tammy Denbo. Because they didn't want it to just be based on the investigation. They couldn't do that, right? Because then they'd look really stupid. But they say, based on the investigation plus online media statements. Therefore, they actually did offer them in this brief as evidence to prove the truth of the matter. Period. They did it. It's right there. So they may, there's an argument. It's all argument. Can't state this enough. You guys want this to be an operative machine, but it's not. Arguments and you're persuading a human. Or three humans, as it were. So, that may bite them. It may bite them. There's no basis for this court to reverse the trial court's award of attorney's fees, expenses, and sanctions. Judge Shep awarded Funimation its attorney's fees and expenses at the trial court and appellate levels, and he entered a monetary sanction of $5,000. In his brief, Vic presents no arguments challenging the amounts awarded to Funimation. That's because he's challenging the award based on the fact that he says that the charges should come back. I don't think he actually is challenging the $50,000 amount. Because Judge Shep's dismissal of the claims pleaded against Funimation was entirely proper. This is the one section for Funimation that I think is well done. They don't waste word count on this at all. And they flat out said, look, his argument is that it wasn't proper. Not that the amount wasn't proper. They're tacitly admitting. And Vic, to Vic's credit, they didn't argue that the amounts were improper. They simply argued that the imposition of the fees was improper because it should have survived Tcpa. Not that if this stuff does fall on Tcpa that the amounts are improper, because they're fine. Like, really? 50 out of 120,000 or whatever? 170,000, I think it was. Could have gotten a lot worse. Blah, blah, blah. There's no reason for the court to reverse the attorney's fees. And of course, if they reverse even one of the causes of action against Funimation, they're going to reverse part of the attorney's fees. That'll be part of it. Just how it'll go. Conclusion and prayer. There's no reason for this court to disturb the trial court's dismissal of Vic's claims against Funimation, nor is there any reason for this court to disturb the trial court's award of attorney's fees, expenses, and sanctions. Interestingly, they don't make the argument about the whatchamacallit? Contingent fees. And that's, they don't even make the argument that those are proper. They just ignore them. I think Volney's done a good job on this part. Ignore them and let the trial court deal with it when they try to collect, if they get to collect. The appeals court may not want to hear about those at all. Anyway, accordingly, Funimation respectfully requests the final judgment of the trial court be affirmed in all respects to Funimation. There are obvious problems with this document. It's not the worst appeal brief, but they may have gone ahead and they may have made a problem early on. Let's see. Here we go. Let's see. So here's this part. Because of the allegations circulating on social media about Vic, Funimation asked Human Resources Department. Tammy Denbo investigated allegations made against Vic by his anime co-star defendant Monica Rial, by two fans who interacted with Vic at a convention, and by a former Funimation employee. Based on her interviews of the two fans, Rial and of Vic himself, among others, Denbo concluded that the allegations against Vic were credible, and her conclusion was reported to Funimation. So it's kind of, that's not the smoking gun that I was hoping it was, but I would argue that the among others has something to do with it. I'd have to go back and look at her things, but they should clearly state that the online commentary was actually used against Vic. You should make the argument either way. Either way, you should make the argument, and we'll see what they do. We'll see what they do. Well, guys, like I said, Funimation's got some problems with the document all around. It's not that bad of a document. It's good arguments for Funimation, but they do have some real issues. And let me be clear on this. It doesn't mean they're bad lawyers. This is a 70-page document, okay? It's a 70-page document. And you've got multiple people working on this document. You're going to have some stuff that might interfere with other stuff. And you read through it and read through it and read through it. But by the time you're done reading, really reading paragraphs at a time. Like you're just and zoning out. It's your own work or the work of your colleagues who you trust. It gets hard to actually edit it. So it's very possible that there are arguments in there which contradict other arguments and could lead to issues that Vic's team will have to raise on appeal. Vic's team has a huge job ahead of it. They've got 3 responses to deal with and 1 cross appeal. If I were them, I would be asking for extra time. I don't know if they're going to ask for extra time, but they have a ton to do. If I were them, I would also ask for 7,500 words per response, per defendant, which would put them well over their 27,000 word total word count. I would ask for it, absolutely. There are too many issues that are different between the parties that they will have to spend a lot of time talking about, and I don't think they can do it in one 7,500 word response. I just don't think it's possible. So I would be immediately asking the court for an extension of time because of all of the issues and all of the parties and how complex they are and the volume of the documents. I mean, you've got 2 parties who have gone right up to their limit, over 10,000 words, and there are significant arguments to address in each of them. They should go ahead and ask for those extensions and graces. They'll have to do it to the parties first. If the parties object, they will look like pieces of shit. They might do that. And then they will have to ask the Court of Appeals and say, can we get an extension on this? They may not do that. That's what I would do. I'm just a guy. I'm just me. Just me. My law firm is just me. So I don't know how many resources they have available to expend among their other matters, especially during COOF virus. Who knows? But that'll be up to them. I'm just telling you what I would do. I would request an extension. I would request an exception to the word count limit, and then I would get my ass to work, hammering them out as soon as possible. And so far, I've seen plenty to attack in each of the briefs, and I think they can do it in their word counts, and we'll see what they come back with. We may not see it till May or June. Who knows? All right, guys, that's what we've got for the documents tonight. Let's go ahead and read through the chats. We'll get on Twitch in a little bit and have a good time. Tomorrow will be Ronversations 10. Bring yourself. Bring a friend. Have some fun time. It's Corona-chan, baby. I know you ain't going anywhere. I know you ain't going anywhere. Knight of Hopex says, I love Q. But your man's civics knowledge is not good. Ooh. Oh, wait a minute. Q called me out on Bible knowledge and now his civics knowledge is in question. You need to re-explain to everyone why they don't have a right to be safe in public. You don't. You don't. We'd have to ban many things if assumption of natural and ubiquitous risk was not part of our civil society. No, that's the whole thing. That's the exchange of freedom, is that you might get coofed on right in your goddamn mouth. Right there. It's possible that you will get sick. There's no right to not have an infectious disease transmitted to you. Now, the intentional transmission of an infectious disease may be a civil cause of action or criminal, but it has to be intentional. To intentionally transmit HIV, for example, you have to put your semen in someone or your blood or whatever. You have to do that. Intentionally transmitting COVID is not walking around in public going, that's not the intentional transmission of a disease. Even if you know that you might negligently do so, might negligently transmit a lot of things. Guy with hepatitis C who takes a shit in a public bathroom doesn't intentionally transmit hepatitis C to everybody else who goes in that public bathroom. Just doesn't. Doesn't work that way. Or is it hepatitis A? I don't remember which hepatitis you can get from a toilet, but it's one of them. It's not even reckless. You don't know that the person knows that they have COVID. You have to prove that. Now, you may be able to prove it. Someone's diagnosed with COVID. They're coughing their damn lungs out. Sure, maybe. Maybe it's reckless at that point. Maybe not. Reckless disregard is an evidentiary. It's an evidentiary question. You got to prove that they were reckless. You got to prove they did it. Prove they didn't have some otherwise important thing that they were trying to do. You can mitigate torts by having some better reason to be doing something. Anyway. Yeah, so it doesn't automatically work that way. Next says, government exists to facilitate society, not shut it down. I agree. So shutting down society in order to protect people from all the risks that society involves is counterproductive. Yes, that is a gulag at that point. I agree. Trading freedom for safety gets you neither long term. Correct. Also, tacitly quoting Ben Franklin. Night of Hopex says, our pretend conservative and pretend libertarian friends are going to have to get less fascist real fast. This is going to be the new business as usual. That's the thing you guys don't... Not you guys. You guys who agree with the shutdowns aren't grasping. The next virus, even if this one is as bad as they say, the next one might not be. And it will push towards the weaker virus till eventually we just shut down a lot of things. Both parties have emergencies they can manufacture to run things with an iron fist. Last chance, wake up. Thanks, Night of Hopex. I agree with everything you just said. Good job. Gamerhands Jr. Inc. says, hey, Mr. Rackets, what's up? Mr. Beard, I see you in the chat. Y'all giving him some love. Also, Nick, can I get sponsored on your channel once I get done with this gameplay I'm doing? Thanks a bunches. Also, the chat, drop some hearts for you, boy. Sponsored? I don't know. I do accept sponsorships, if that's what you're saying. I accept money to promote things. You can talk to me about it like anybody else would. But or you could super chat and promote your own channel. I don't care. Mercenary X says, Mr. Obvious just did a video about some Chinese lady who's super happy about her hoarding face masks and says how proud and happy she was denying Americans the needed masks. How much it's going to hurt people. She posted on Twitter, please spread C. Okay. Jay says, Funimation made a statement to ANN on the 4th or 5th that Vic was fired. It was in one of the petitions. Hope the reply mentions that. I hope so too. I hope so too. Night of Hopex says, wait, I need you to clarify this for me. If you raise an objection, the judge refuses to rule on it, and you just lose that, refuses to rule on it, you just lose that objection? Unless you show a good faith effort to obtain the ruling. Kind of. It's not that simple, but the rules are that simple. How is that not improper? Yeah, you force a judge to rule on something, see how well it goes. Also, remember the judge told Ty to stop objecting. In the middle of the hearing, stop objecting. How does that play? I don't know. We'll see. If abused, that makes the entire system of justice sham and a waste of time. Welcome to the party, pal. How is that okay? It's not, but it's what we've got. Kay says, thanks for the lecture on why our legal system isn't actually real. It's all just a game of pretend where we hope a judge cares enough to make the fair ruling. What % chance of success do you think these appeals have, Nick? I have no idea. No idea. For the sake of easiness, 50-50, right? They're either going to accept it or they're not. So far, the briefs on all sides are relatively competent. Bad Vibe says early in Eunuch. Misty Dawn Piker says wheelchair user plus dislocated shoulder equals one winged. Wheelchair, I have experimented with going in circles quite a bit. Prayers would be much appreciated. Oh, man. Misty, that sucks. That sucks. Hopefully someone will help you get out of the circle. Andrew War Snowboard says the Cuck movie made $0 at the box office. Wesley D. Aguayo. I gotta get Drexel here to do a Let's Watch of Cuck. Wesley D. Aguayo says we call her crazy grammar cat lady who goes crazy over the simplest grammar error. Oh, okay. SJ Jar Jar Bink says, have you tried dapping through the anger, Nick? It helps. You can drink too if you're skilled. Dapping? You mean dabbing? I don't know what that means. Bad Vibe says, if people can knowingly spread ST disease, who cares about the beer flu? Oh, sexually transmitted diseases. Yeah, who knows? Olron1 says, think you'll do Warhammer 40k lore videos on your other channel? Maybe. I mean, Lutein is so good at it that it's hard for me to imagine doing it. I'd definitely love to hear you explain that stuff. Maybe I'll just give my take on it. I don't know. We'll see as it goes. SJ Jar Jar Bing says, if you believe things as bad as they are, do you foresee people going 1776 if this keeps up for too long? That's an easy answer. Yes, too long is subjective. Who knows what too long is? That's the question. Chengiz Khan says, government takes away people's rights because of virus. People, is that legal? Government, Palpatine voice. I will make it legal. Frost287 says, hey, Nick, first super chat. Hey, thanks, buddy. Keep up the awesome work. And could you pour one out in honor of my father who passed away last Friday? Thanks. Oh, I got some beet vodka left. It's not meant as an insult for your father. It's just already in my glass. Sorry. Peace to you and your family. Beet is a hard pill to swallow, just like the death of a loved one. Nothing Raven says, sweet, a weekend show. I have weekends off and I enjoy to catch you live. Haven't been able to get Glenlivet Naduras yet, so I'm just drinking 12-year. 12-year Glenlivet's good, though. Bad Vibe says, isn't the Kamea context evidence of Sony investigation being known before the funny tweet termination? Yes. Confirming MR's claim of investigation? Yes. Yes, it is. And again, of Monica Rial being more than just a contractor. Participating in an investigation and tweeting about it with authority. That's apparent. Colosign says, what are your thoughts on pastors being arrested for holding church against the government's wishes? Corona is fear fodder. I think it's terrible. I think it's a violation of the First Amendment. I think those pastors should not be holding church, to be clear. Don't go to church. And people should not be attending. Don't go to your church. But we have a First Amendment right to freely exercise religion, and shutting down a church service is a violation of that right. There's no way around it. There's no way around it. It should be a lawsuit. Pastor of a megachurch, the megachurch should absolutely file for a violation of their rights and set it up that you can still meet. You know, like this sounds cheesy and corny, and I get it. Again, don't go to church right now. I'm absolutely not going to go to a church during Corona Chan. Are you kidding? But I'm someone with nowhere else to go, losing all hope and afraid of coronavirus and what it's doing to people, and I'm a believer. Bet your ass I'm going to a church. I'm going to look for guidance. I'm going to ask my deity, whoever it may be, or I'm going to go to the mosque, or I'm going to go to the synagogue, or I'm going to go to the weed circle if I'm a Rastafari. It doesn't matter. I'm going to go to the child sacrifice if I'm Ruth Bader Ginsburg. You're going to go ask your deity, from Yahweh to Molech, what to do if you're scared. Of course you're going to do it. And it's silly to say that people can't do that, and that's not a free exercise of their religion, that they should just, quote unquote, stay home, bro, and check it out on YouTube, bro. What if your church isn't doing YouTube? That's not sufficient. It's not the free exercise. And again, they shouldn't go. That's not the rights. Rights are that you can, even when it's hard. Hildred Castagne. Dana White is being sued for not paying someone who allegedly kept his name out of a blackmail scandal. Please explain. I've never seen this. I'll try and look it up. No one important says, actually, Rial's character does the raping. Oh, no. Rage DMX 47 says, anime and grift Israel. Bad Vibe says, you can't spell liar without Rial. Zetrock sent a hot dog and a peach. Oh, boy. What are you into? Rogue says, off the top of my head, I recall Monica Rial has voiced 2 lolly vampires. Lady Luna, 13 years from Moon Phase, and Mina Tepes, 400 years from Dance and the Vampire Bund. She tends to voice a lot of lollies. Oof. Jason the Great Awakening says, should this go to proper trial, which I believe it will, is it likely any lurking Machiavellian BS behind the scenes regarding SJW power play come out? If this goes to trial, a lot of people are getting deposed, and it'll be glorious. Glorious. We all gotta wait. I don't want to hype it. Man, if this goes to trial, you get to depose everybody. Hammer Bro, thank you for donating. Nick Naylor says, how's that whole heat allergy thing work in the bedroom? Are you a permanent bottom now? No, you just suffer, buddy. Let's just put it that way. You know, let me put it in a different way. You have a built-in indicator of whether you done good, son. Whether you done good. You put in the effort, it literally shows on the body. Rage DMX 47 says, tonight's guest Tonka saw and all his dead air. Damn. Nothing Raven says, why Monica hasn't married Ron? ? He's a wife beater. Ron beats women. Not a girlfriend fiance beater. So if she never becomes his wife, she has nothing to worry about. Also, I think she's just stringing him along because I think she's a total bitch too. Or Ron. Poor wife beater. Shadow Goff says, Your Honor, I like to state for a fact that this YouTuber, Nick, is a public figure for he has 80,000 subscribers. Thank you. They'll literally try that. Make no mistake. That'll come up at some point. Clumsy K says, do you think they're trying to clutter the response, making it tiresome for the appellee and the court? Yes, absolutely. Also sent you some fan art. Check your email. I will do this. I will do that. Mickey Vicky says, can we play that Destiny cut clip? I don't have it ready. Harper Leo says, check your Twitter DMs since I don't know your pleb email. It's in every description. Keep on keeping on. Hope you and the Racket family are healthy. We are. We're all doing great. Thank you. Thank you for your concern. Bad Vibe says, Kafifi is the cure for COVID-19, I think. Harper Leo says, also say anarchy in all caps out loud. Alexander's ER staff here. It is as bad as it seems. Yes. Interesting. Interesting. Bad Vibe says gift givers and bug chasers exist. Just saying. Alexander. Now, I'm not arguing with you. I don't know. I'm not in an ER. I'm not in any of these places. What do you say to retweets by people like Barnes Law, Robert Barnes, and Michelle Malkin and stuff like that, who are saying that they have hospital staff DMing them and talking about how they're laid off and their hospitals are empty? I'm not arguing. I don't know. I don't want to enter into that discussion myself. You don't have to send money, but if you could tag me in the chat and let me know, like, what do you say to those types of allegations? Because I've seen a lot of them coming from a lot of regular conservatives about this idea that that it's being overblown because hospitals aren't full as they're supposed to be. So there you go. Bad Vibe says, gift givers and bug chasers exist. Just saying. SJ Jar Jar Binks says, okay, slightly more dark and serious question. Can you have your constitutional rights and stay safe with an enemy you can't see, Corona? No. No, constitutional rights are the opposite of safety. That's the point. You have a right to travel, even though traveling takes you away from your home and subjects you to the whims of everybody else. You do. Traveling on a road subjects you to horrific consequences. You could be run over by a car at any moment. You could be slammed into by a semi-truck. The right to a gun provides that someone with a gun will use it improperly. Maybe on you. It's a risk that you take. Right to free speech means that someone will say something you don't like. Right to religion means that Scientologists exist. It makes us all in danger. It's all, I mean, everything's rights are risks. And if they're not risks, they're not rights. They're just things. Just things that exist that are normal. Again, please and thank you aren't rights. Because someone says please and thank you to you and you're fine with that. Someone calls you a cuck beta bitch and you might have a problem with that. You might want to shut them up. I don't know. Someone says that Ron Toye beats women. Ron Toye has a fucking problem with that. Ron Toye and Monica Rial really hate the fact that they're liars. And I'm calling them liars publicly. You'll see tomorrow. They hate it. Monica Rial and Ron Toye are lying. And they know they're lying. As far as I can tell. They're fucking pieces of garbage. They're shit bags. They are lying to destroy a man. They wanted him to die. I'll say all of it again. They wanted him to die. They knew that disconnecting Vic from his fans would risk putting him in the ground. and they were fine with it. Monica Rial and Ron Toye wanted Vic Mignogna to kill himself. Of course they did. Because anybody who knows Vic, as well as Monica must know Vic, would know that doing what they did to him would risk putting him in the ground. I'll say it with confidence over and over and over again. Because knowing Vic, by March of last year, I knew that about Vic. By March of last year, I knew that what they were doing to Vic could put him in the ground. They definitely knew. Of course they did. And I'll say it till the cows come home, no matter how much they don't fucking like it. Monica Rial and Ron Toye are pieces of fucking garbage. And, as I've said a million times, don't ever talk to them, don't ever engage with them, don't ever bother them. They don't deserve to be harassed. They deserve to be mocked like the pieces of shit that they are. That's it. We can all mock them here. Right here. I didn't invite them to this live stream. They don't have to endure any abuse. You can literally never click on it. We can all make fun of them because they're fucking garbage. Trash people. Trash people who tried to kill a man over their petty bullshit. There we go. I think that was thorough. Okay, did Alex... Oh, here's Alexander. Says some hospitals are getting less patients with toe pain, less of the patients with toe pain or small complaints. That is only because the virus hasn't hit their area yet, like the water receding before a tsunami. Well, I'll be watching, man. I hope I'm right. Not because I want to be right, but just because that means less people die. That's it. Next. Clumsy K says, Lemon Voice. She was a contractor. Oh my God. You've heard of John Deere, but have you heard of cunt lips tractors? I want to get my bronchial sacs around those cunt tractors. Romeo Garbo says, a bearded man sitting in front of a red flag drinking vodka. Have I seen this somewhere before? Maybe I'm just tired. Yes. Yes, you have. Moist John says, you think Funny saying that they didn't say Vic did anything and the rest saying Funny told them Vic was a predator will ever get finally questioned? I don't know. I hope so. Kyle says, beet vodka. Ha! Up here in Canada, we have milk vodka. Google vodka if you're interested. Oh, gross. SJ Jar Jar Binks says, well, then further questions. Laws get changed, so when they do, and a right is converted into a privilege, then what? Rights aren't laws. Laws don't confer rights. Rights are something you already have, and they're recognized. If a right gets converted into a privilege, it's tyranny. Period. Jade Rose of Chaos says, hey, Nick, what do you think about the hypothetical corona vaccine being touted as the mark of the beast by conspiracy theorists? My hyper-religious mother keeps worrying, FFS. I don't know if the corona vaccine is anything at all. Who knows? Mark of the beast? Gotta mark you somehow. I guess you gotta watch what they do with it. I think it's nonsense. Everything's a mark of the beast these days. Biblicists are looking for the mark of the beast everywhere that they can, and they have been for 2,000 years. Because Revelation says that Jesus is coming tomorrow, no matter when you read it. It's a problem. It's a problem. Why I have a problem with Revelation. Great on imagery and poetry, bad on prophecy. What's falsifiable about it? Nothing. How do we verify any of the claims? We don't. And it's why they debated heavily on even including it in the biblical canon. So it was about to go the route of the Gospel of Enoch, or the Book of Enoch, and the Book of Adam and Eve, 1, 2, and 3. And he was about to go apocryphal route. It got thrown in at the last minute. I'm not a big fan of Revelation. I don't trust it. It also doesn't tell me anything fucking useful about my life. So, you know, take it for what you will. People who look to Revelation for... Have you noticed how many antichrists there are? Literally every president ever is a biblical antichrist. It's because no one knows what it means. And I like the approach from Bad Omens? Good Omens. Neil Gaiman and Gaiman and Stevenson? I don't remember the other. Neil Gaiman anyway. Good Omens. Prophecy always works in hindsight. It's not really useful for predicting things in the future. There you go. Hopefully that helps. I mean, you can't stop someone from thinking about it, but it's pointless to consider it. Pratchett. Terry Pratchett and Neil Gaiman. Thank you. Thank you. Great book, by the way. Love it. Love it. The beet vodka prevented me from remembering Pratchett. Yes, thank you, chat, for completely fisting me on that one. The Lord of S'more says Bard Rekieta used vicious mockery. Super effective. Nick Naylor says good response to the heat allergy, but that's going to bite you in the butt 10 years from now when you come out of the bedroom looking like a tomato and your kids totally know what's up. Look, if by the time my kids are adults or even teenagers, they don't know what's happening when Lady Rackets and I are having a very serious discussion in our bedroom with the doors locked, then I'm going to disown them. Kagi Onsai says, hit that perfect beat. Show us now your feet. Lane 20 says, remove all doubt. Ignore MSM attacking Trump. The number of cases are on the rise and the numbers are 10 days behind. Stock up, hunker down, and stay away from strangers. I just hope that by Matsuri, I can go to Houston. That's all. Disabled Llama. Hey, Nick, please check out channels LeoY86 and Serpent ZA. There's a third, but YouTube is censoring the name. Okay. I saw some video about those guys. Mauricio Romero says, what are your thoughts on Tesla making respirators? They make them? I thought they just bought them. And I thought they were like CPAP style device, BPAPs or BiPAPs devices. I don't care. If Tesla can make an electronic car, I think they can make a respirator. Bad Vibe says prophecies are also self-fulfilling, which is just as dangerous. All right, guys, that's what we got for tonight. I will be on Twitch for a little bit. Coom Eternal. Hang out. Let's get this outro going. It's not playing. No. Hold on. Muted. My fault. Now it's still not playing, even though it's... Dang it. Oh, it's on the wrong thing. It's on the wrong speaker output. Just a minute. This one. Because I changed my headphone jack. There we go. There we go. Did you miss all the Justice Chats? No, I read all of them. How did I miss yours? Damn it. I'm sorry, Siren. Siren Jag says, as Lemoyne runs my private dancer, a dancer for money. He'll do what I want him to do. Eyes to the wall, Ron. I missed just yours. I'm sorry. It was right after Spirit Juniors. And I don't know how I didn't see it. I apologize. Please forgive me. Please forgive me. And then finally, J Meister JAD says, with his outro muted, we'll laugh at this boomer. Yes, thank you. Thank you. All right, guys. Thanks for hanging out tonight. I'll see you over on Twitch. Peace. Peace.
As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more of love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folk from Doug Tater spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed, so pour out a glass for the tea. Post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have.